Please allow. Worship, I beg to mention item 25.
Item number
25.
25.
25. Learned Counsel Mr.
Your name?
M.S. Alam.
M.
S. Alam. M.S. Alam.
M.S. Alam. You are appearing for response
Response
6.
6 slot.
Interim order may kindly continue.
Wait, there is some interim order.
Yes.
Okay, interim order to continue.
My lord, item number 63 in the supplementary list, my lord. In this matter, my lord, I have filed an additional affidavit, my lord, that will be taken, my lord.
Sorry.
In the item number 63 supplementary list, my lord, I have filed an additional affidavit, that will be taken.
Mr. Decca. Sorry again. Yesterday you were very adamant. The argument you were raising will not lead you a order in your favor. But there is an alternative argument, please look into it, which goes very much in your favor.
Surely, my lord, I have a judgment of the today.
No, that will also not work, possibly. It's a totally different argument.
Obviously.
Look into all the aspects carefully. There is a very good argument for you. And it is likely to lead in your order in your favor because we are more concerned with your client than your arguments. So we
saw in November
are under a constitutional obligation to do justice to the litigant before the court. So therefore, we are indicating it to you. One you are raising will and when you indicate something, there is some meaning to it. Your adamancy will not help you in any manner. Take note of that.
Item 1 for withdrawal.
The petitioner is already appointed on
Withdraw your name, please.
A. Khandakar on behalf of Mr. B.P. Bora.
A.
Khandakar on behalf of Mr. B.P. Bora.
No, withdrawal cannot be on behalf of. Ask Mr. Bora to come. Ask the order. Another learned counsel cannot withdraw a matter, even on behalf of.
2 and 3 for admission motion.
Yes.
It's the last order, my lord.
For education department. Why was this order passed? What we intended to look into?
My lord, they have started second process without completing the first process.
Okay, where is the first process?
First process initiated, my lord, page number 44.
Page number 44.
44.
Yes. And second process?
Second process, interim process, page number, my lord, 61.
61. Your district is Baksa?
Yes.
What is the meaning of the last paragraph?
My lord, the director
No.
going to proceed. First paragraph.
No.
Yes.
What is the meaning? Yes. What does it mean? The earlier process will be completed, or it will
Not
be?
completed, my lord.
It will not be
Not
completed.
completed. The director want to process two separate pays.
Sorry.
Two separate pays wise. Earlier one is another and
Understand that. Are you completing the earlier one, or
No.
you are not completing?
no.
You'll abandon that. Mr. Chisti, please, see what is meant by that?
It is not clear.
No. Director will say.
See, case of the petitioner is there was a earlier process initiated in 2021, that
Yes,
page
my lord.
44.
Yes.
His case was also considered. He is also a candidate in that process.
Yes.
Now by page 61, you have initiated one more process.
Yes. Yes. Per
So he is agreed by the second one that without completing the first one, why do you initiate a second one? Therefore, we wanted to know what happened with the first process.
it is pending, my lord. Not
Pending.
pending.
Will you complete it or you will abandon it? Because your last paragraph does not
It is not clear.
carry any meaning.
You want to compete with the board process. You want to.
And he also says
Hmm.
candidates included in the first process
Yes.
are also included in the
Yes,
second
second
process.
Yes.
So ultimately, what does it mean?
Ultimately, Lordship, the director said that he has no objection if the honorable court may deem fit and proper.
See,
That ultimately
we are not here to
Yes,
take
Lord.
administrative decisions.
Yes.
It is for the administrative authorities to take the decision. We'll only
Their instruction.
He is not hearing his.
will only make a judicial review whether it is as per law or it is not as per law. We are not going to take your decision. Peruse the communication dated 21/9/2023 of the Director Education BTC, the last paragraph of which is as expected. The director to clarify as to whether the earlier process initiated under the
Letter dated, my lord.
letter dated 8/2/2022
21.
2021 would be completed and brought to its logical end, or it will be abandoned and merged with the subsequent process initiated by the letter dated 36/2023. The specific information be provided to the court. List on next week.
Next Wednesday.
Sorry.
Wednesday, next Wednesday.
See, if you abandon, we'll examine whether you can abandon or you cannot abandon and whether it will affect the legal right of somebody. If you complete, you complete it. We'll allow you to complete it.
Item 4.
Yes, item 4.
Madam, letter pertains to amalgamation of
Authorized.
schools, madam. My lord,
Amalgamation.
yes, madam. Page 26.
26.
Page 26 is the important notification.
Where is your serial number? The Kurban Ali.
Kurban Ali,
Merged with Mirzapur.
Mirzapur Gang.
Why do you challenge it? On what ground?
My lord, the ground on the page 8, my lord, I have discussed this all grounds.
Please tell us.
That the school, the distance between the school is more than 1 kilometer.
More than one.
More than 1 kilometer. Is it issued with a GP certificate? Is there, my lord, regarding the distance?
Where is the OM?
OM, my lord,
Providing that it should be within 1 kilometer.
my lord, page 31,
31 relevant page.
relevant page 34, my lord. Serial number
34 has been superseded by some subsequent one.
subsequent also within 1 kilometer. Here it is half kilometer.
So where is it? Why are you relying on the
Subsequent is
Mr. Counsel? Why are you relying on a notification which has been abandoned and a new notification is in place? Rely on the new one. Where is the new one?
This is not in the record, my lord, but I have collected
Bring
yesterday.
it. That doesn't mean you rely on a notification which is no longer having force. I know you are right. New one provides for 1 kilometer, but you have to rely on the new one, not on the old one. The petitioner relies upon a notification of the education department, which provides that in order to effect a merger of two LP schools, the distance between the schools should be less than 1 kilometer. The relevant notification may be produced.
Item 5.
Pursuant to the direction of the Honorable Court, my case was considered. Pursuant to the direction of the Honorable Court, my case was considered for provincialization, and at page 24, by order dated 26 June 23.
Yes, why appointment letter not issued?
Yes, my lord.
My lord, I have received incomplete instruction, my lord. Kindly give another.
Incomplete
Yes,
instruction.
yes, yes.
My lord, for twice, my lord, I have stated in para 7. My lord, when my
Mr.
petitioner.
Talukdar, we
No.
cannot bulldoze
No, no,
the.
no, no, I'm not saying that.
status
My lord, I'm.
form. Only once time was given.
Yes, ma'am.
So it was, Mr. Girin, sorry, Mr. Ganesh Pegul and Counsel for Elementary Education Department states that the information received with reference to the order dated 8/9/2023 is incomplete and therefore some further time would be required. Pray aloud. Based on so and so for the information.
After 10 days, my lord.
Item 6, 9th October.
Obliged.
Please, my lord. Matter pertains to
Whether the application was placed before DLC, was it placed? Same order. MS S50, elementary education. Information is not available. Yeah, I go to G2 Dilu.
Item 6, item 7.
7. On the prayer, Mr. Kondakor, Stanley John.
In this case, my lord, I am language teacher, private respondent number 6, also language. I joined on 1/1/96 and she joined on 6/2/2008.
Provincialization.
Provincialization.
Under which act?
Under 17.
17 Act.
Act.
How many posts are available for language teacher?
On one.
Only one. Where is that schedule?
Schedule, my lord, as per enrollment, my lord, one.
No. Where is the schedule to the act providing for only one post?
My lord, it may be increased on the basis of enrollment, but enrollment is low, my lord.
Let us look into it. Where is the provision? Language teacher means it's a higher secondary school.
No, ME is coming.
ME school, do you have language teacher?
Yes,
Let us look at the schedule of the act which provides for this thing. Number of posts.
My lord, my lord, page 111.
111.
My lord, Roman 6, Roman 11, my lord. That is section 3(1)(11). My lord, page 111.
Was Roman 11.
My lord, in case of Venture Upper Primary School, there shall be minimum 3 teachers.
3 teachers or tutors.
My lord, at least
1 teacher each for so and so.
1 for science and mathematics, social studies and language.
So the other, who is the other person?
Other person, that is respondent number 6.
Where is the comparative data between the petitioner? Who is the petitioner? Petitioner is Jubeda.
My lord,
Okay.
that is
Jubeda was appointed on
page 31.
What about page 33?
Page
What is
31
this?
is the approval list.
No, no, what is page 33?
Page 33 is the dice code.
Dice code, let us see the dice code. It will contain the actual information.
Dice code, my lord, year
Zubeda
of,
Khatun,
my lord, year of joining is there, 1996,
96.
my lord. Then
Then
Reshma Khatun, serial 5.
she is a teacher of which subject?
She is a teacher of main subject or 2.
Uh,
2, my lord, right column, my lord, 2. Lordship got it 2. Main subject taught, then below,
where are you reading?
page 33.
No, 33. Where is main
My lord,
subject studied up to?
classes taught,
Classes taught, 2.
then my lord, main subject taught 2.
2 is
2 is now, my lord, in below. 2 means
2 means language.
language.
Okay.
And 1 means all subject. That is Reshma Khatun,
So,
it is 1.
Your sub classes taught 2. This is language.
Language. my lord.
And who is your respondent? Resma
Reshma Ahmed, serial number 5.
96. She is also 2.
He is subject to main subject 1.
No, classes taught 1. Okay,
2.
main subject
1.
2. She is all subject,
All subject.
all under.
My lord. So,
And what is the date of appointment?
her date of appointment, my lord, date of appointment, my lord, that is, I have also annexed in
96.
no, that is wrong, my lord.
No,
In-
please tell us the date orally. You
that
don't have
is-
to refer to all
Yes,
those
my lord.
papers.
He was 6 to 2008.
6 2 0 8 0 8. Date of appointment.
08.
Date of appointment.
Date of joining, my lord.
No, it's stated 1996.
Yes, that is wrong in Dutch code, but in page, my lord, your lordship come to page.
And what is your date of appointment?
My date of appointment is
1/1/1996.
1/1/1996.
1/1/99.
Appointment is 30/12/95. Joined 1/1/96.
1/1/96.
96. Joined.
Okay.
Joining.
1/1/96.
96.
Heard Mr. Amar Khandapal, also heard Mr. Ganesh Pegul and Elementary Education Department. Anybody else? No.
No, my lord.
Notice 6 weeks, extra copies 3 days. The provincialization of the respondent number 6, Reshma Ahmed, is assailed in this writ petition on the ground that both the petitioner and the respondent number 6 are language teachers of the school concerned. Whereas the date of joining of the writ petitioner is 1/1/1996, whereas the date of joining of the respondent number 6 is 6/2/2008, and therefore it is claimed that admittedly the writ petitioner is senior to the respondent number 6. But ignoring the seniority of the writ petitioner, provincialization had been meted to the respondent number 6. In view of the further provincialization of the further provincial and its benefit to the respondent number 6 shall remain state until further orders. This after 6 weeks. Steps on respondent number 6. Any other private respondent?
No, only 6.
Only 6. Rest 1 to 5, Mr. Pegu. Sorry. Count 3. 6 or registered for 3 days.
Item 8.
In 8, my lord, I am science teacher. Initially, my lord, my post district scrutiny committee recommended.
Forget about your history. Ultimately, what happened and what is your claim?
recommended in terms of honorable court's order.
You are accommodated.
I have been recommended by the district.
So now why are you before the court then?
And now district scrutiny committee is sleeping over the matter.
Sleeping. You wake up the committee if they are sleeping.
My lord, they are not taking any
No,
action.
if somebody is sleeping,
It's pending before the SLC, most probably.
since how long?
As district level.
Since how long?
Since it has been recommended. my
No,
lord,
sleeping since when?
20.
Huh?
22.
Almost 1 year.
1 year.
13
Ask your
October.
SLC to wake up.
Rachi will dispose it of with a direction to
Heard Mr. Amar Khandapal for
the elementary.
The limited grievance raised in this writ petition is that the concerned district scrutiny committee had recommended a petitioner for provincialization as a what teacher?
Science teacher.
Science teacher in which school?
In Jogipara ME.
In Jogipara ME school. But when the records were transmitted to the state selection
State level
state level
scrutiny
scrutiny committee. The matter is kept pending without giving it a final consideration. In view of the limited grievance raised, the state level is directed to complete the process of considering the recommendation made in favor of the petitioner by the district scrutiny committee dated.
Dated, my lord, meeting 20.
No, date of the recommendation, date of the district.
Recommended 29/9/22.
29/9/22 within a period of 2 months from the date of receipt of the certificate copy of the order. Disposed of accordingly.
9 and 10.
My lord, it is 27/9.
Please correct it and give it to the
27,
record.
9/22.
Yes, next time.
Your Lordship, they have been called today to appear before the scrutiny committee.
Tea garden. Lordship, this is the report of the interim.
Okay, it stated that the committee to consider the caste certificates of the applicants to the first year MBBS course had been constituted, and the committee would start its functioning from today.
9:30.
Already.
Had already started it functioning in course of the day.
By paper publication as well as email, but not everybody is in.
And the respective candidates had been informed through paper publication. Let the process be completed. Let's take a video.
26. The 26 was fixed.
27.
On
27 was fixed.
Please complain.
The interim report is there, Lordship.
Sorry,
The interim report is there before your Lordship.
we accept the interim report for this, Mr. We complete it fast. That's all.
Accordingly, we have directed the DCs also, concerned DCs also,
Just find out which tea garden where you work. That's all.
that we have directed the DC.
And item
concerned
120.
deputy officer.
Thank you.
Item 11.
Yes, Mr. Rashid.
Maybe. This is regarding amalgamation of ME school with high school.
Sorry,
Amalgamation of ME school with high school.
ME school?
ME school. ME madrasa.
Teacher of ME school, then what happened?
It is to be, model has been passed by the Millard, the director Millard, to be amalgamated with the high school.
So your school will be amalgamated with the high school.
Yes.
You are agreed?
Agreed.
Why?
Millard, as per there is a Millard, OM Millard, as per OM Millard, it should be Millard, that is violated. 11 Millard.
Where is the OM page number?
Page Millard. Page 21 Millard, you can see. OM dated Millard 3rd of August 21.
Clause number?
Page 21 Millard, close 11 Millard.
11. To optimize use of teachers
the
of a
use of
two-class high
service
school,
of
one
teacher
nearby ME school having
of a
poor enrollment. Less than 35 students in each class may be merged. However, in case of hilly areas, difficult area, the distance norms shall be reduced as per suitability. What is the distance from within 5 kilometers?
No, it should be 3 kilometers.
No, para 10, 5 kilometers.
My lord.
So 2 or more high schools.
High school Millard.
5 kilometers. What about ME school?
ME school Millard, that is Millard 3 kilometers.
Where do you get that 3 kilometers?
Less than
Class
35.
10 is high school, 5 kilometers. Where is ME school?
ME school Millard, 2-class high school nearby
it's
ME
an,
school having 4
12.
enrollment, less than 35 students in class, less than
Class 12, Mr. And now, what is your grievance?
Grievance is
Your
Millard,
school has more than 35 students, or the distance is more than 3 kilometers?
this for distance about 3 kilometers by students is more than 35% Millard, about 67% Millard in the school.
Not percent, the fixed number. Less than 35 students in each class.
More than
What is the number of students in each class of this school?
67 Millard. An extra 1 Millard I have
An extra 1.
There is a KG to class
Just a
7,
minute.
610 students Millard. It comes to 67% Millard.
ME school, we should take note of class
6, 7,
6, 7, and 8, I think.
Yes, Millard. And they have more than 100 students.
Lordship, in this matter, first of all, my lord, if your lordship turns to page 24. In page 24,
You'll ask us to go to the secretary.
my lord, there is this thing, my lord, if there is any grievance,
No.
he should go so that, my lord, he has not appealed before
Grievance
the
and doing something in violation of law are two different aspects.
my lord.
So secretary can so moto take note of it, it's a different matter, but we are going to stay it.
And also, my lord, one more thing, my lord, if your lordship comes to annexure 1, there, my lord, there is overwriting regarding the number of students, though there is page number 17.
Where is the overwriting?
My lord, in if you see class 4, your lordship, so we need to verify that also.
Class 4, we are not interested. We are ME school, we take note of 6, 7, and 8 only.
7, also 7, your lordship. 149.
And
148.
Suppose the overwriting is wrong. Instead of 9, even if you read it 0, what will be the figure?
My limited, my lord.
You're limited. Suppose we read the wrong overwriting to be 0 instead of 9. What will be the figure? 140. Will it not be more than 35? Then why should he take note of all this?
I'll get my instructions, your lordship.
You take your instruction, file your affidavit. We are passing our orders.
My lord,
there
is a mechanism, my lord, made by lord already, my lord, the office, my lord. Where they
See,
can approach.
there cannot be a mechanism by violating your own rules. Grievance is something different.
I leave it to you.
Or else we dispose it off, we stay it, take note of the authorities that the stated figure of the students is this much, which exceeds 35, pass appropriate order.
That may
In the meantime, don't effect the merger till the order is passed.
My lord, that will be my lord.
Okay. Heard Mr. A. Rashid, learned counsel for the petitioner, also heard
My lord, I'm appearing for the elementary education. And
Elementary Education Department, Mr. S.M.T. Chisti for the Secondary Education Department, Mr. Saikia, P. Saikia for the Deputy Commissioner Borpeta. Full stop. The writ petitioner being the school managing committee of Mokhwa Ujirer Chor ME Madrasa is agreed by the order of amalgamation dated 17/6. 17/6/2023 of the Director of Secondary Education Assam, by which the petitioner school is sought to be merged with which high school?
Ujiresar High School.
Ujiresar High School.
No.
High school is Ujiresar, ME school is Mokhwa.
Yes, right.
The petitioner raises the grievance that as per the office memorandum dated 3/8/2021, clause 11 therein, there is a provision that to optimize the use of services of teachers of a 2-class high school, one nearby ME school having poor enrollment, that is less than 35 students in each class, may be merged with the high school. Clause 12 further provides that this is for ME school. Where is the provision of one ME school, one high school? Distance is not there, I think.
That is 11 is ME school with high school.
No.
That is regarding class.
That is only class distance. 10 is for merging of 2 high schools. 12 is for merging of 2 ME schools.
No.
Where is the provision of 1 ME school and 1 high school?
On high school, yes.
Distance.
That is
13. 5.
I have to see a high school.
Not 5. Not 5.
7/5.
7
Roman 5.
7/5. Okay.
7 Roman 5.
7 5.
No distance is given.
I have also.
Distance is not given.
Only number of students will be given, my lord.
ME school, high school, only number of students. Doesn't matter how far the schools are.
Even 7 kilometers, school bigger. 7 bigger land. I have also checked, my lord, but there is people I have missed.
There is not there. ME school, high school, it is not there. কি বলো? কি বলো? Clause 11 thereof, comma. There is a provision to optimize the service of students having important 35 students in each class may be merged with the high school. Okay. ME school is stated to be from classes 6 to 8. Accordingly, in order to effect a merger, the condition precedent to be satisfied would be that for the classes 6 to 8, the number of students in each class ought to be less than 35. Mr. Rashid, learned counsel petitioner, points out to Annexure 1 to the writ petition, which gives out the enrollment strength of the school concerned in respect of classes 6 to 8, and states that in the Mokhwa, Uzirich or ME Madrasa, the number of students in class 6 is 109, in class 7 is 140 or 149? 149, and that of class 8 is 151, comma. Accordingly, full stop. Accordingly, it is submitted that the number of students in the petitioner Mokhwa school is more than 35 in each of the classes between class 6 and class 8, and therefore do not satisfy the condition precedent of clause 11 of the OM dated so and so. In view of the above, we remand the matter back to the Director of Secondary Education to examine the enrollment strength in classes 6 to 8 of Mokhwa Uzirich or ME Madrasa, and pass a revision order to the effect that in the event the number of students is factually found to be less than 35 in each of the classes, the merger may be effected, and if it is found to be more than 35, the appropriate order be passed, strictly in compliance of clause 11 of the OM dated so and so. Till such revision order is passed by the director, the merger of the petitioner school with so and so school shall not be given its effect.
Item 12.
It's open for you. We passed our interim order. Till you pass, don't give effect. You can take a. Yes.
May I please, the Lordship? Lordship, matter pertains to non-provincialization of service of the petitioner, my lord, who is the only science teacher of his school, my lord. This is the second round of writ petition, my lord. Earlier, this honorable court may have directed direction, my lord, to verify my claim whether I am the only science teacher or not. Page 32.
So now what is happened? Somebody else provincialized, or no one is provincialized?
My lord, science teacher has not been provincialized yet. Page 32, my lord. My lord,
reasoned order, I mean, has been Lordship directed on the last occasion to give a reasoned order, whether to consider, whether or not to consider. So the order is at page 42, your lord.
42.
And my lord.
What is the reason?
My lord, may I read, my lord?
Decision in view of the above findings.
Fifth para, my lord, page 42, my lord.
Hmm.
Fifth para, page 42. That is the, my lord, reason. May I read, my lord? To the basic of honorable court order.
So the reason is, however, as per clause 31, that is the reason.
No, my lord, the DSC not know the reason for non-recommending the petitioner.
Sorry. No, this order is by the director.
Yes, ma'am. DSC not know the reason, my lord. That is
The reason is, my lord, why his name was not placed. They have not given the reason, my lord.
No, no, you come to the third paragraph from bottom. That is the reason.
No.
However, as far as possible, the recommendation of DSC is necessary. If it is necessary, get it.
My lord.
How can you prevent it?
My lord. Recommendation from the district scrutiny committee is necessary.
The director ought to have written to the DSC.
My lord.
Whether you recommend or don't recommend, give it to us.
My lord.
How can the director avoid or will impose a cost? Yes.
Last chance. We'll ensure.
No, we have already, when there's a direction of the court, you are required to do it. Who prevented the director to not to do it? The DSC is an authority under the director.
My lord. That is true.
I'll,
my lord.
So,
sure, my lord, time frame, my lord, and
so can I pass a judgment? Mr. E. Fukon for the elementary could not produce the relevant documents. Writ petition dismissed. Can I pass a judgment? Don't you think the director had done the same thing?
My lord.
Yes. Your subordinate is not giving the information. Why will you refuse provincialization for that reason? You call for the information from your subordinate. Heard Mr. S. Hazorika, learned counsel for the petition also. The petitioner Ismail Hussain claims provincialization under the Act of 2017 against the post of science teacher in which school?
My lord, Anwar Hussain, ME Madrasa.
In Anwar Hussain, ME Madrasa. Full stop. When the petitioner with the same grievance approached this court earlier by way of WBC, where is that earlier order?
My lord, page 32, my lord.
32. By way of WBC 312-2022, a direction was issued to the Director Elementary Education Assam to examine the claim of the petitioner and pass a reasoned order. When the court directed the director to examine and pass a reasoned order, it means that the director will do all the necessities, all the necessary acts as required under the law and pass a reasoned order. The result, the requirement of the order dated so and so resulted in the order dated 24/12/2023 of the director. 24/7/2023 of the director, wherein the following conclusion was arrived.
No.
However, page 42. It is noticed that instead of examining the matter as per law and doing all the necessary acts, the director had abdicated the responsibility merely by providing that as the recommendation of the DSC is necessary for considered provision, therefore the claim of the petitioner would have to be rejected. If there is a requirement of a recommendation by the DSC, it is for the director to obtain such recommendation from the DSC. If under the law, the DSC is agreeable to give any such recommendation. On the other hand, the director can call for a report from the DSC that it is not agreeable to make any such recommendation. But it cannot be a situation that because there is no recommendation, the director will reject the claim of the petitioner. Accordingly, the matter remanded back to the director to pass a fresh order by doing all the needful as indicated above. Reasoned order be passed within 2 months from date of receipt of the certified copy of the order.
The district elementary education submitted report before the director, and in that report they said DEED and DSC not know the reason for not recommending it.
In other words, we are clarifying that if there is no recommendation by the DSC, the matter is to be placed before the DSC. DSC will consider and pass a reasoned order. And the said reasoned order will be transmitted to the director, who shall thereupon pass the required order, pass the order as required by the order of the court.
13.
Yes, 13.
Matter regarding compensate appointment.
Sorry.
Compensate appointment.
DSC.
Petitioner application is not.
Was it placed before DLC?
Not placed before DLC.
Not placed.
Not.
Are you sure? Yes, Mr. Second. Placed or not placed?
Page number 22 minute.
We passed that. We passed that half-baked order. Place it before DLC. If already placed, inform him. No point in issuing notice and keeping it pending. Heard Mr. A.H. Alamgir and counsel for the petitioner also and Pokan Arohiri, the DDO. The father of the petitioner. Abu Bakr Loskar was an assistant teacher in the 526 number. What is this? Practicing school. Number practicing school in the Hailakandi district. Who died in harness on 25/11/2013 on his death. The petitioner submitted an application for compassionate appointment on which date?
There is a receipt date 25/12/2013. Page number 22.
Date is 25/12/2013. It is claimed that the said application was not placed before the DLC concerned for its consideration. In view of the limited grievance raised, writ petition disposed of, directing the district elementary education officer Hailakandi to first verify from the records as to whether any such application had been made by the petitioner, and if any such application is available, to place the same before the next available DLC of Hailakandi district. In the event there is no such application is available, the petitioner to be informed accordingly. And on the other hand, if it was earlier placed before the DLC and any order had been passed, the petitioner will be again informed accordingly. And in such event, no further requirement to place it before the DLC.
Item 14.
Yes, Mr. Islam.
May please, Your Lordship. My Lord, petitioner by this petition, my Lord, pray for similar relief as passed in the my Lord order.
Mr. Islam, first you have to state your case. Then you have to state what was passed provided in the other case. Then third stage you say that give me also the same relief.
So apology, my Lord.
Otherwise, how can you pass an order?
My Lord, petitioners herein are working as my Lord education volunteers.
Education volunteers.
Shiksha Mitra, Shiksha Kurmi, Shiksha Sarati, under the my Lord education grantee scheme of Assam Service Mission, my Lord.
So now,
my Lord, they are discontinued from their service from time to time.
And in respect of other similar series, some order has been passed. Where is that order?
My Lord, order, my Lord, Annex 3, page my Lord 73.
Page 73.
Page 73, operating part, page 78.
Page 78.
Starting, my Lord.
Yeah.
There are 5 is the my Lord.
Yes, Mr. Bora, pass the same order. Heard Mr. M. Islam, Land Council petition. Also heard Mr. S. Bora, Land Council for the SSA.
Lordship.
And MS Tutia for the Elementary Education Department. All the petitioners herein claim that they were engaged as
my Lord, engages my Lord, education volunteers.
Education volunteer.
Volunteers.
Stroke Shiksha Mitra.
Shiksha Mitra. I have given details in para 8, my Lord.
We don't want so much of details.
Shiksha Kormi, inclusive education volunteers.
Inclusive education volunteers.
Shiksha Sharati 1.
Bracket
Shiksha Sharati 2.
slash diva. Shiksha Sharati 1, Shiksha Sharati 2.
2. Community volunteers.
Community volunteers.
Sanjukta Shiksha Kormi.
Sanjukta Shiksha Kormi.
My lord.
Enough.
My lord, enough. Paste table I have given in para 8.
Take it. It is the standard of respondents that the engagement of this category of employees had been discontinued in as much as the scheme under which they were appointed had in the meantime been discontinued. In the circumstance, certain similarly situated persons had approached this court by way of WPC 336/2023, wherein the order dated 23/6/2023 was passed, which is extracted as below. Taking note of the similarity between the petitioners of the present writ petition and the petitioners of WPC so-and-so, the same order is also passed in the present writ petition, meaning thereby that the writ petitioners may also file their respective applications before the
Respondent number 1.
Before the
Secretary School
before the secretary to the Government of Assam in the School Education Department within a period of 2 weeks from today, and in the event of any such representation being submitted, a reason order be passed within a period of 2 months from the date of receipt of the representations. Disposed of as indicated.
Similar petition number 3667.
Correct.
Highly obliged, your lordship.
Item 15.
Yes, Mr. Nazir Hussain.
May it please your lordship. Matter relates to compassionate appointment, lordship. Matter is
Compassionate.
pending.
Was it placed before DLC?
Yes, lordship. Matter
What?
is pending before the DLC since last 4 years. lordship.
Pending. They are not passed
Yes.
any order.
As per letter dated, lordship.
Page number.
Yes, lordship 34, lordship.
34.
33, 34.
33, 34.
Yes, lordship.
What is this? 33, 34. Mr. Soike, does it indicate it is pending? Just check up. Is it, if it is pending, you pass a order. If it is not pending, tell us, is it pending?
My lord. Right now,
No, Mr. Hussain says it is pending.
My lord.
Page 33 and 34.
My lord.
I have not understood what page 33 and 34 is. So therefore, we are asking you,
My lord.
is it pending or it is not pending?
My lord, I am a little confused, my lord, regarding this, my lord. In Seniority itself said that it's pending before
Point out
SLC, my
the
lord.
relevant line where it is
More than
stated that
3
it
years,
is pending.
Lordship, I have submitted subsequently representation.
Hussain,
Yes, lordship.
you have submitted that page 33 and 34 shows that your petition is pending.
No, lordship.
Point out which line of 34 and 35 shows that it is pending.
Lordship, there is a communication letter, and till now I have no information. I
So
have
you,
not received any
then why
information.
did you make an incorrect submission that page 33 shows that it is pending?
No, sorry, lordship.
Please don't.
This is
Unnecessarily
the
you mislead us to some other
communication letter,
direction.
lordship. Annexure 10.
You don't know the outcome of your application. What is
Yes.
your submission?
Yes, lordship.
Mr. Hussain, think once again.
Fine.
Tell us your submission, what you want to submit.
My submission is, lordship.
We'll respond to your only to your submission. Please submit. What is your submission? It is pending or it is not placed or it is what?
I have not received any.
You don't
information.
know anything about
Yes,
it. That is your case.
That
Let's
is
say that.
my case.
Just-
Synopsis, my lord, said that
He
this
doesn't know
case is
anything.
recommended 2018
Sorry.
by the DLC. My lord, the synopsis says 31/5/2018, his case is recommended by the DLC, and
We don't know
but the copy of the
synopsis.
recommendation had not been communicated. to the
Mr. Saiki, a
petitioner.
synopsis is not a part of the repetition.
My lord.
We don't rely on any
Otherwise, my lord,
synopsis.
apart from
What
that,
had happened? Tell me. The respondents to inform the court as to the outcome of the application or petitioner for compassionate appointment made on
Lordship, I have filed application
22/5/2012.
22/5/2012.
22/5/2012 on the death of his father, Sukur Ali, who was an assistant teacher of Dekasang Ansolik High School in the Kamrup district and died in harness on 5/4/2012. List again. On.
Item 16.
Case lordship. LC rejected the case of
Page number.
petitioner lordship. Relevant page 39.
39.
October.
What is the name? Noor Hussain.
Noor Hussain lordship. Serial number 5 lordship.
Noor Hussain. And who was recommended? Who was recommended then?
Rejected lordship.
Reject, I know. Who was recommended?
Case 24 lordship.
Hmm.
Communication letter. DI of school.
I know out of
Sorry,
these,
Lordship.
out
That's
of these 5 or 6 people who were considered, who was recommended? No idea.
Lordship, DI of school, Deputy Inspector of School forwarded the proposal to the District Elementary Education Officer. Lord.
We understand that, but
Lordship.
ultimately was anybody recommended or not recommended?
Not recommended.
Not recommended. No one is recommended.
No.
You say DLC had rejected your case,
Yes, Lordship.
but now you are saying it was forwarded to the DLC. Mr. Hussain, you prepare your case and come. We'll list again. Oh, sorry. 30, 36. Who is he? Who is the person who recommended? Mr. Saikya, for the first time, we have come across a case where financial comparison was done. So we want to know who is recommended. If the correct man is recommended, possibly he has no case. And if the incorrect man is recommended, we will pass some order. So who is recommended now? Because every time you reject with all vague grounds, but in this case, the comparison has been made. Madam Sukia, you pointed out something. Who is recommended?
Number 36, my lord.
This is Bilasipara. Bilasipara, who is recommended?
District Dhubri.
Recommended for the post of Debo Prasad Sheel. Why did you recommend Debo Prasad Sheel? Page 35 of the recommendation of the DLC dated 14/6/2010. 14/6/2010 will be not relevant because this man, when did he die?
2008. Lord.
Oh, so maybe that 2000 shows that in respect of Bilasipara, Devo Prasad Sheel had been recommended for compassionate appointment in a post of teacher. Page 38 and 39 comprises of certain financial, inter-se financial comparison of the respective candidates, where the name of Devo Prasad Sheel does not appear. Respondents to produce the information and the entire records of as to why Devo Prasad Sheel was recommended and whether there is any credible material on the basis of inter-se financial comparison to recommend Devo Prasad Sheel to the detriment of the others whose names are included in the financial comparison at page 38. List on
17.
Please, your lordship. This is also appointment on compassionate ground.
DLC.
No, lordship, not placed
Not
before
placed.
the DLC.
Same order tomorrow.
Lordship.
We'll place it.
Lordship.
Firstly, they'll verify whether your application is on record. All of same order. Give the particulars: name, school, date of death, name of father, and all.
Lordship.
Next.
Is there, lordship, a verification has already been done in case of petition.
So how does it make a difference to you? Let it be placed before the DLC.
18.
Yes, Madam Chaudhary.
Matter relates to compassionate appointment,
DLC?
my lord. It was placed before the DLC, but the DLC rejected without assigning any reason. Page 27. ma'am.
27. What's the name of this man?
Name, my lord, Shabir Ahmed.
Sabir Ahmed. Sabir Ahmed. Where is Sabir
Serial
Ahmed?
number 30 at the bottom, my lord. At the bottom, my lord.
Yes, 27.
Page 27.
27, yes.
My lord. At the bottom, serial number 30, my lord.
30, Sabir
Yes, ma'am.
Ahmed. Huh.
Yes.
The claim of petitioner for compassionate appointment stood rejected by the DLC in its
Dated
DLC of
17
Karimganj in its meeting dated
17/6/2013.
17/6/2013. By the same resolution, Annapurna Bhattacharjee and some other candidates were recommended, while Sabir Ahmed, along with (35) others, were rejected. The internship financial comparison that may have been made by the DLC, comprising of the entire records, be placed before the court. We'll see whether they have done the work or not.
Item 19.
Yes, Mr. Bora, go ahead.
They are diploma holders in pharmacy, recognized by my lord, central government and other pharmaceutical institutions. My lord,
Your read petition is 84 pages.
well, actually 12 men, everybody's.
No, your read petition
Yes.
minus the annexure is 84 pages.
Yes. Only because of the
To
certificates
register
and
under
everything.
the law.
So what happens, my lord? Then
They have already passed out.
passed out.
Huh.
Then there is a provision that for 1 year they will have to go to practical training.
That internship kind of a
Practical
thing.
training.
Huh.
And that was not forthcoming, so we had to come to High Court. High Court said that give them the training. So we have completed training.
The training.
Permitted. Now the final thing is that we should be registered by the Assam
Pharmacy
Pharmaceutical
Council.
Council for doing practice in the line.
Hmm.
So for that, my lord, from the year 2022 November, we have all have submitted the required fee of
Yes, Mr. Gogoi, why are they not registered?
Well, that part, let me have the instruction.
The respondents in the
Assam Pharmacy Council.
Assam Pharmacy Council to provide the information to the court as to why the writ petitioners have not been given the registration.
Yes, my lord.
In spite of having the necessary qualification, including the qualification of having completed the 1-year internship. Respond.
My lord, your lordship kindly see 47, page 47. Annexure 47, my lord, page 144. Interestingly, my lord, the registrar cum secretary of Assam Pharmacy Council.
43.
44. Annexure 47, page 144. This is a letter written by the register pharmaceutical.
No, that is okay.
No, that is my intention was to show your lordship that on the interference of the pharmaceutical Assam Pharmacy Council, we have been permitted to perform the practical training.
No, that is okay. Let us have the reason why they are not doing it.
My lord, your lordship, the tendency of this rule, because from it is 7 to 12.
Pendency of the writ petition shall not be a bar for the respondent Assam Pharmacy Council to do the needful if so advised. But we have not yet issued notice. Why should there be an interim order? Let us have the reason.
No, my lord, by 7 months,
Okay,
12 months.
so issue notice return for 6 weeks, extra copies 3 days. Pendency shall not be a bar.
Item 20.
They are sitting over there.
Mr. Buragohai, we wanted to do something in your favor to dispose of on the next day.
Okay, man.
As you were not wanting it, let us there be a notice.
I appreciate it, man.
Let there be a notice then, 6 weeks. We thought that we'll dispose it of in 7 to 10 days. So therefore we passed that order. But you don't want it, what to do? Bring us the information. If the information is that if they can be registered, we can dispose it of. Yeah. But in that case, we cannot pass any interim order. Both cannot. Next date এটা দি দিব for the information.
3rd October.
আগতে যেটো দিলো সেইটো দিব.
20.
Yes, item 20.
The petitioner is aggrieved by the provincialization of services of the respondent number 7.
You are both we are competing with each other.
Yes, in effect.
There is only one post.
For that particular one post. And the petitioner had filed a writ petition earlier. The lordship, what had happened was the petitioner is serving as the principal of that school. And I was serving as an assistant teacher in social studies, social sciences. Now,
No. I and the petitioner, what is the difference?
the petitioner, the respondent number 7 was serving as the headmaster. And the petitioner was serving as an assistant teacher.
So now it's a provincialization as teacher or as principal?
As teacher.
As teacher.
Because his services have been provincialized as teacher, and his date of join, he is admittedly junior to me, Your Lordship. There is one order passed by Your Lordship, which is at page number 48. The facts will be clear from that order, Your Lordship.
Page 48.
Page 48. Your Lordship. The relevant portion is at 49.
As per physical verification report, respondent Rajan Pator. Who is Rajan Pator?
This is the private respondent.
Private respondent. Rajan Pator appointed on is a language teacher.
We are not concerned with that language.
And no, respondent number 8 appointed on so and so.
Yes.
And who is the petitioner?
Petitioner is Nibharani Boro.
Nibharani Boro, teacher in social science. And Rajan Pator is a teacher of which subject?
Social studies.
Both are social science.
Both are social.
So the matter was remanded back
to the committee.
And what order has been passed?
The committee has passed an order, Your Lordship.
Page number?
Page number 56. It is on the basis of a report which is at 55. This issue has not been decided.
No, just made 55.
56.
Arun Chandra Bhaduri, this is the school.
This is the school.
Madam Chotia, why the DO had submitted that proposal? The District Elementary Education Officer Kamrup Metro to show cause as to why a proposal as referred in the order dated 22/8/2023 had been forwarded to the Director of Elementary Education Assam, to the Secretary to the Government of Assam in the School Education Department to provincialize the following teachers, Rajan Pator, Doli Hari, in spite of there being an earlier order of the court wherein it had been noted that Rajan Pathor, although the headmaster had been appointed on 27/1/2005 and is seeking provincialization as a
assistant teacher,
social science teacher in the school. And the writ petitioner Nivarani Boro is a teacher in social science, having been appointed on 3/2/1997 and admittedly senior. The report of the DO be placed before the court on the next returnable date, list on so and so.
4th October. Item 21.
Caveat just.
Till then,
Till the next returnable date, the provincialization of response shall remain state.
So far, the contention of the petitioner is that he is teaching also social science, and the respondent number 7 is also teaching social science. The document shows Lordship, she is actually teaching language, and so far the respondent number 7
No,
is
the entire records of the appointment of all the teachers will be also produced. We are passing an interim order, admittedly senior.
That's true, but the subject concern is different. Lord.
Mr. Deca, your submission will depend what will come in the records. But what is already on record is the date of appointment.
That is the contention of the petitioner. Lord.
We have passed our order. Next item. Next date. Next date, you make a submission. Bring all your material, you also bring your material. We decide it. Mr. Deca, we are primarily satisfied on the basis of date of appointment.
True.
Just a minute. Your dispute is she is not teaching social science.
Yes.
That fact has to be determined on the basis of records. We'll determine it.
That may be indicate Lord in the record.
Oh, yeah, don't worry.
Because otherwise, Lordship, since 2017, Lordship,
it will be done. Don't worry.
That will
further orders to be passed shall be considered on the availability of the records.
Right.
List on so and so.
oblige.
21. Impleadment of party.
Yeah, produce the firstly and all the particulars, your duty teacher allotment, in which class, who is teaching, everything.
Yes.
And we are not sending it back to the director again.
Attendance register.
We'll decide it here only,
Yes.
because
Lordship.
director is not
Yes.
doing the work.
Oblige.
Yes, ma'am.
Your Lordship, this petition is filed for improvement of the newly incumbent.
Mr. Chisti, there is a tendency of provincializing the headmaster. I have noticed it. It's a general tendency. Unfortunately, for LP school, there is no post of headmaster to be provincialized. So how to exclude the headmaster? Throw away somebody else, bring the headmaster in. This is a general tendency. Yes, madam.
Kindly impeach the newly incumbent of Lordship, Commissioner and Secretary.
IA for
IA for the impeachment, Lordship.
Whom do you want to implead, madam?
Commissioner Secretary of the Government of Assam, Director, Inspector of School, and the Headmaster.
All of them.
All of them.
Secretary school.
Kindly see page number 8 of paragraph number 5.
Have they been informed about the order?
Yes.
Her your name?
And they.
And they learn counsel for the applicant. By this interlocutory application, the petitioner intends to implead. Where are the names?
Page number 5.
No, whom do you want to implead and who were earlier impleaded?
Earlier impleaded, Lordship, Commissioner and Secretary, Director, and the Inspector of School. Three numbers.
This is a contempt petition by name, not by designation.
Yes,
so we want the names of the person who were already impleaded and names of the person who you intend to implead now.
Okay, Lordship.
Please,
Pritam Shrika is the Commissioner Secretary of the earlier stage.
the petitioner to file an affidavit as to who were the respondent containers already impleaded in contempt case 537/2020 and who are the intended respondent containers who are sought to be impleaded in the contempt petition list on so and so. Next item.
Lordship. In paragraph number 5, I've already mentioned, Lordship.
Then you should have said that answer when we are asking you.
I've already mentioned, Lordship, in paragraph number 5.
So many people are waiting behind you. We have to attend to everybody's case. So if you develop the habit of giving the straight answer straight away, it helps us. It helps you also. If you cannot give, you come prepared next time. Specific question, because we'll have to add them in addition to the earlier one. So we want the specific names. Okay. Or else write in a piece of paper that these are the people already implemented. These are the people we want to implement. We'll pass the order. Timing koribo niki? Kuro, jodi lage timing koro. Yes, next item.
22 for admission.
When the matter was called on 24/2023, none appeared for the petitioner. Today again, when the matter is called, none appears. This for non-prosecution. Mr. Ganesh Pegu appears for the elementary education department, and yourself
6 and 7.
for 6 and 7.
23.
Lordship, in this matter, the petitioners are aggrieved for non-provincialization of service, even though their cases were duly recommended by the DLC as well as by the state level committee.
Today, what used to be done? Can you hear the matter?
Lordship.
Are you ready, respondents?
No, we have filed a affidavit.
No. Can we hear the matter today? Or you want to examine it? Sorry?
Pleadings are complete, madam.
I know pleadings are complete. Are you ready with the hearing or you are not?
Not any other day.
Any other day? Okay.
Short date review.
It's stated that the pleadings are over and the matter can be given a consideration as agreed with counsel.
5th October. 24.
Yes. Affidavit filed? No.
Instruction awaited.
You want to file? Mr. Asa Dava for which respondent?
For PTC,
For whom do you appear?
Malad.
For whom do you appear?
BTC.
For the respondent, say BTC prays for how much time?
For 3 weeks time. 3 weeks.
3 weeks time to file affidavit, pray out this after 3 weeks. You also want to file?
No, my name, I am appearing for student not.
You want to file affidavit? Don't want to file?
Right now, I'm not necessary.
Mr. Ashoff for respondent number 6 do not intend to file any affidavit.
No, only my name may be recorded.
Sorry?
Only my name may be recorded. I am appearing for student number 5.
Recorded.
You want to file affidavit or you don't want to file? If you want to file, we'll allow you. If you don't want to file, we'll close your affidavit.
Let them file their affidavit on the.
We cannot keep it conditional in that manner. How can we keep it conditional that in the future even he may file, may not file? You want file. As for also makes a similar prayer. Responsibility.
6.
Mr. Hawk,
here.
you want to some advice in lawyering? Do you want some advice for lawyering? How to conduct yourself as a lawyer? Do you need some advice? Take time. Next time, don't file. Say, I want to some more time. And if you want to depend on this state affidavit. But how can you foreclose yourself from filing?
Yes.
Maria Garbanglong had taken 4 time in far back in December, Malad, filed the affidavit.
Karbi Anglok had filed.
No, Lordship.
You want to file?
Yes, Lordship.
MS came try from the authorities in the KST praise for
3 weeks time, Lordship.
3 weeks time. This after
Lordship,
3 weeks.
IA,
What IA?
IA is there, Lordship.
IA was in this.
IA said 3240.
Yes, 324.
We have to take up the IA today.
Yes, Lordship. It came today.
IA, yes, you have filed one IA also. For what purpose?
For deleting the name.
Sorry?
For
They
deleting
were
the
afraid that the name of the applicant petition of court from the
striking of the name.
Striking of the name, I think.
number 4 you want to strike out.
I think all the names will stock out. 14 number.
This IA, it has not been disposed of. This IA.
But here my notice, my lord, already
Mr.
out of
Sharma.
32, 14 is drawn on
Mr. Sharma, there is a IA filed by the writ petitioner
Yes.
to strike out writ petitioner number 4. Do you want him to be strike out or you don't want him to be strike out?
Yes, sir, because they have
You
got
want. Heard Mr. R.P. Sharma, learned counsel for the Senate counsel for the petitioner, also heard MS Kemprai for the KSC. Mr. Anybody else? Any other private respondent? Any other respondent, Madam Kemprai? Education department is there.
Education is there.
Education department, yes.
For the
Lordship.
elementary education,
State of-
SSA is also there, I think.
Yes, Lordship.
Elementary education is there.
Mr. SMT Chisti for the elementary education department, and anybody for SSA.
SSA is also.
Where is Bora gone?
Asil.
Blank account that I have already.
I will inform.
No. ISC 3240-2022 has been instituted for striking out the area of respondent of the writ petitioner Balesar Chauhan as writ petitioner number 4 in WPC so and so. Upon hearing the land counsel, Mr. R.P. Sharma, respondent writ petition number 4, Balesar Chauhan is deleted from the area of writ petitioners. The petitioner shall continue with the other writ petitioners. However, for convenience, the seriality of the writ petitioners may not be altered. I allow indicated.
27.
I to Dipo. 3 weeks. Yes, 27, Madam Das.
Entitled for provincialized under 2011 Act, my lord, but they are provincialized under 2017 Act. My lord, may please turn to page number 36, my lord.
So you are provincialized.
My lord.
Now you want it under the 11 Act.
Yes, my lord, because
Lordship,
district.
here, Lordship, I have to inform this honorable court regarding a judicial order, Lordship. So I forgot to, Lordship. There's a judicial order passed by Honorable Chief Justice, Lordship, regarding all provincial matters, Lordship, that will be listed before a special division bench considered by the Honorable Chief Justice, Lordship. Regarding all writ petitions, all single judge writ petition, Lordship, division bench writ petition and appeals. This is the order, Lordship. So I have to inform your Lord.
Take it up with the registry.
Yes.
Special bench.
Just Lordship, I peruse this order, Lordship.
And where is the special bench?
That it was already set for one, Lordship. Now.
Very different bench, take it away.
That is why I have to. It's my duty to inform this court, Lordship. That's why I'm.
Yes. Registry ঘটক কি কৰিব লাগে মাটি ফালে ঘটক what is to be done with this matter
Order actually.
Eight.
Your Lordship, kindly peruse the last order, 26th of July.
26th
of July, last order. 26th of July.
Regarding this case, Lordship, So my instruction, do I have received it verbally that yes, it is.
What is your claim, case, Mr. Hussain?
My lord, we have challenged the impugn order, case 34. my lord.
Case 34.
Lord, I'm-
Look, who is the petitioner?
My
Professor
Lankeshwar
Deori.
Deori.
Professor Deori, WPC 8790. Even if you have been appointed as
Earlier court order is, my lord, is 28. Now, your lordship kindly peruse the first order while issuing the notice, my lord. 25th February 2022.
where is the order dated 11/20/2019?
Page 28.
Page
Lordship.
20.
20?
28.
28. These are the difficulties when you accept these kind of orders from the court. The day you take the order, you are very happy. Yes, my petition is disposed of. But it's neither here nor there.
Yes, sir.
My lord,
So if nothing happens, everything goes well, it is a very good order. But if something happens, we cannot decide anything beyond that.
now, and then, my lord, if
Why don't you require the court to pass a little more, something more in detail?
And moreover, he was appointed in a provincial school by the managing committee, Lordship. That was
A lot of factors are
that
there.
was already barred by this honorable court.
So
Lordship.
ultimately, what is wrong with this order?
my lord,
Page 34. Where is the illegality in this order?
my lord, so far, my lord, I take your lordship 25th February 2022, honorable court order.
Sorry.
25th of February
Page number
22, my lord, while issuing in this case, my lord, first order.
No, that will not give you any right.
No,
These are all interim observations.
my
It will
lord,
not give you
only
any right.
I am trying to
Now tell us.
sequence, my
No,
lord,
no, Mr. Hussain, we are not going to all those things.
my lord, no,
Tell us
yes,
where is the illegality in page 34, which is the impugned order,
my lord. If
so that we can examine your case.
Exactly. My lord, I take your lordship page 34, my lord.
We have read it.
Moreover, my lord, fourth paragraph. Moreover, government of
We have read it.
my lord.
What is wrong with that order?
Wrong is, my lord, when there is a specific rule for recruitment for the
Recruitment
post of grade 4 employee in a provincial school, my lord.
Okay, that rule will not be applicable.
Yes, my lord.
So now let us read both the rules.
Yes, my lord. This notification come later on.
Mr. Hussain will hear your arguments later on. First, let us read both the rules. The rule you are referring and this rule. No. If you don't,
That is, this,
Mr. Hussain, if you have not read the rule, how can you make a submission? The rule is not applicable.
my lord,
The writ petitioner
that is why, my lord, last
the writ
August,
petitioner claims that
It is there, man.
Mr. Don't go that way. The writ petitioner claims that the order dated 16/3/2022 is bad in law in as much as the said order refers to the Assam Direct Recruitment Commission for analogous post in Class 3 and Class 4 Act 2021 to be the relevant statutory provision for the recruitment, whereas the petitioner claims that the relevant statutory provision ought to be the name of the rule. You are referring.
Assam Direct Recruitment Commission for analogous posts.
What are you doing, Mr. Hussain? Name of the rule you are relying on.
My lord, Assam Secondary.
Assam
Secondary Provincial Service Rules 2018.
The writ petitioner to produce both the statutes before the court for its examination. Based on sense. Date will get it. Produce both the rules. You say you are governed by the other rule, not this one. We'll examine the two rules and take a decision.
The petitioners are the grade 4 employees of the secondary schools in the Kachar district, my lord. They have been aggrieved for not considering their candidate for promotion of the grade 3 post.
Agreed by
for non
promotion.
Yes, they are
presently they are working as
a grade 4 employees.
Grade 4, yes. Grade 4 to grade 3 promotion.
Yes.
How many petitioners are here?
5 petitioners are there, my lord.
In one school?
No,
or different school?
In different schools. In different schools. It is my lord.
So this promotion is school wise or district
wise? It's otherwise
common wise.
Yes.
Suppose a man in X school, he can be promoted in another school.
Yes.
Are you sure? Where is the rules? Let us see.
Rule, my lord. Rule.
Which rule?
2018 rule, my lord.
2018
rule, my lord. Rule 5.
2000.
That is
page number.
Page 26, my lord.
Are you holding the same book or different book? Same page number.
26, my lord.
26.
5-2.
The secondary education provincialized rules 2018, that one?
Yes, sir.
Rule, which rule?
Rule says
promotion from grade 4 to grade 3, which rule?
5-2, my lord. Limited direct recruitment from grade 4 to grade 3, my lord. They have introduced.
Yes, Mr. Sharma, how do you interpret rule 5.2?
It is from open competition. Here it is mentioned, it is open competition.
Where is it mentioned? Open competition or
Rule 2 and the last line, my lord.
No, it is not. It is not written. Please read it carefully.
Yes. 5% of the total post of junior assistant of a district
of a district. This is why I asking.
Yes.
5% of junior post of a district. So the entire district.
Yes.
Shall be filled up by direct recruitment from the candidates.
Yes.
From amongst grade 4 staff of the schools.
Yes.
So now of the schools means respective school. Say school X.
Yes.
Promotion within the school X from grade 3 to grade 4, grade 4 to grade 3, or
school.
Do you maintain a common gradation list of the grade 4 of all the schools in the district? Do you have it? Do you have any common gradation list of grade 4 of all the schools in the district? Do you have that list?
Right now, I have no.
You have to give us that information. Otherwise, how do you implement it? There are two ways you can do it. One, identify the schools within the 5%. Say out of 100 schools, we designate these 5 schools to be within the 5%. Then whosoever is a grade 4 in that school will be promoted. Then another school will raise a grievance that I being a grade 4 for another school, why I will not be promoted. Other option is you'll have to maintain a common gradation list of all the grade 4 of the schools in the entire district. From that list, 5% of the post will be promoted. Do you have any common gradation list? And after having this is not open competition because Mr. Sharma is C, and the remaining posts shall be filled up by direct from open competition. Direct is open competition, not the promotion. The respondents in the Director of Secondary Education Assam to inform the court as to what procedure had been laid down to implement the promotional process provided under Rule 5.2 of the Assam Secondary Education Provincialized Schools Rule 2018. Also as to whether a common gradation list of the grade 4 staff of the schools in the district are maintained so as to give effect to the process of promotion. List on. If you don't have, we have to pass an order. You streamline and then do it.
Item 30.
Yes.
This matter relating to appointment of a president, nomination of president of a high school lordship. The government was directed to file affidavit. Whether they will file or not, but I have not received popular.
Who wants to file affidavit?
Respondents and government.
No one has filed. No, some affidavits are there.
No, he have to file lordship, but they are directed to file lordship.
No, some of its affidavits are already
This is
there.
from the private respondent and headmaster lordship.
Sorry.
Headmaster has filed and the private respondent lordship has filed. And official respondent was supposed to file lordship.
Respondent number 3. Who is respondent number 3? Deputy Commissioner.
Yes, sir.
Because Madam Borman appeared.
Yes, madam. Yes.
MS Borman.
Must be Deputy Commissioner. What is your claim?
My case, lordship.
Oh, what is the grievance?
Grievance is lordship. I am the selected candidate lordship to be selected as a nominated as a president lordship. My name was in the first list. President lordship.
SMC.
SMC president lordship.
Yes.
My name was in the first lordship.
Who had given your name?
Headmaster school authority lordship.
What is the procedure?
Procedural lordship, inspector of school lordship call for the director of the all schools lordship, and thereafter they hold the meeting lordship, they advertise lordship, and accordingly selected the 4 names.
Advertise?
Even advertise was given lordship. The
School president of school managing committee?
Yes, lordship. To the oil publicity lordship, thereafter lordship, my name was sent lordship.
Show us the procedure. One notification is there.
Yes, notification is there lordship.
I don't think it is advertisement.
The advertise is not, there is no direction
It
lordship.
is not advertisement.
I was selected lordship.
So why did you?
The concerned headmaster is no way.
Don't make a wrong
issue any
submission.
advertisement.
First produce the
Yes,
OM.
OM lordship, the OM is lordship.
These are not civil posts under the government, so that there will be advertisement and all those things.
His intention is to make publicity lordship. So it is oil publicity lordship.
Mr. Counsel, why don't you produce the
Yes,
notification?
lordship, that is in the record lordship. That is in the
Which page?
in the affidavit of opposition of the private respondent.
Page number.
36 lordship.
Page number
36 lordship.
36.
Of additional affidavit in opposition of the respondent, private respondent.
It is my affidavit.
Yes, lordship. This is
For whom do you appear?
My lord, respondent number 7.
Who is he?
My
The
lord,
recommended man.
Yes, my lord. He was appointed as the president of the.
Is he functioning?
My lord.
If there is an interim order, he is functioning.
Yes, my lord. There is an interim order against that person.
He is not functioning lordship.
He is not functioning.
No, no, he could not
What is your
practice.
privacy case?
My case is lordship. He is totally stranger lordship. His name was never sent by the school authority lordship, but he is suddenly
Stranger.
Yes, lordship.
So-
In the proceeding, he is stranger lordship.
Don't get aggressive.
Lordship.
You'll not gain anything in this court by getting aggressive, I'm
Yes,
telling you. Only way out is logically say on the basis of material what you have to
Yes,
say.
lordship.
My
Lordship,
lord,
Your
my
forceful
basic-
argument has no place at all.
Lordship.
And moment you are forceful, we believe you don't have a case.
Lordship, lordship.
Only then people become forceful, when you actually don't have a case.
Yes, Lordship, I'm sorry.
Now point out which relevant provision.
Yes,
Where is the
Lordship.
procedure given?
Yes, Lordship. Procedure, Lordship. The relevant portion, Lordship, page 39, Lordship, of the state approved, Lordship.
There is a difference between arguing something on the road and in a court of law.
Yes,
mind you. Huh?
There is selection.
Lawyers are supposed deemed to be intellectuals. Produce your case like an intellectual, not like a ruffian. Roadside it is different. More forceful you are, better you are placed. No, but not in a court of law. Always keep that in mind.
Page 39, Lordship.
Page 39.
Lordship.
Yes. Where is the procedure?
Yes, Lordship.
Selection. Inspector of school, just a minute. After consultation with the principal, will forward 2 names to the director. This has in the meantime been modified. There is one
modification is there, Lordship.
There is modified also.
Yes, Lordship. That is, Lordship, page.
So now your name is sent by the principal.
Headmaster.
Headmaster, where is it?
And that selector procedure selection list, Lordship, in my read petition, page 18, Lordship.
Page 18.
Yes, Lord.
This is by the headmaster.
Headmaster, Lordship. Number 1, Lordship, I am the Abdul Rahman, Lordship.
School is Adarsha Vidyapit.
Adarsha Vidyapit.
Abdul, and who is Mr.
He is Nur Shahid Ali, Lordship.
Sorry?
Nur Shahid Ali. His name is not there, Lordship.
His name is not here.
That's the
Where is the inspector of school forwarding the names? Because inspector of school will only collect from the, will only consult with the principal.
Yes.
But it will be forwarded by the inspector of school. Where is the inspector of school forwarding?
Lordship, that I could not collect, Lordship. That is, Lordship, that official.
Who appears for the respondents? You produce the records. You produce the records as to what procedure was followed. Because his case is, he says that my principal has forwarded my name. Other side's case is, how do you come in?
My Lord, Deputy Commissioner forwarded my name, select my name.
Deputy Commissioner.
Deputy Commissioner.
Based on what material?
My Lord, kindly page 41 of my affidavit.
Page 41.
It is the type copy, my Lord.
In partial modification, no, this is empowered. Empowered is not the only. On what material the Deputy Commissioner had recommended your name?
My Lord, although I could not annex my application, but for my instruction, my Lord, I applied before him.
No, but the Deputy Commissioner, you have to read page 41 and page 39 conjointly.
Yes.
Page 31 says a specific procedure is laid down, but ultimately the director will make the appointment. Director will forward to the secretary and to the government. Understand? And the government will make the appointment. Now this has been modified that it will be the Deputy Commissioner who will make the appointment. But that does not mean that the previous part of the requirement that the inspector after consultation will forward 2 names to the director, that has not been modified. Only the last portion modified. So what procedure the Deputy Commissioner adopted? Or the Deputy Commissioner says it's my free will, I'll appoint anybody. Yes, who appears for Deputy? The Deputy Commissioner, which district? The Deputy Commissioner Borpeta to produce the complete records of the appointment of the respondent number 7 as the president of the school managing committee, including the materials that were available before the Deputy Commissioner for making such appointment.
You have no wrong, Lordship. There, Doctor already called for Lordship. Doctor already published, Lordship.
Then cancel this order. Don't write this order. List again for further hearing.
Item 31.
May I pray for listing as admission, my Lord, so that the entire matter
doesn't matter.
Admission.
Once it is in the list, it will be taken up. Ultimately, today nothing happened in your case. As no prima facie case could be made out, the interim order passed earlier is withdrawn.
Lordship, it is already there, Lordship, already put his local Lordship. He could already call for Lordship, that's why I'm responded Lordship.
So you don't want. If you don't want, there is no material before us, and you make out any prima facie case. So we don't retain the interim order.
I'm sorry, Lordship.
See, in spite of our utmost sincerity to decide the matters, you, Mr. Hawk, this is not the first time, have a habit of obstructing in this way or the other way. It's not the first time with you, mind you. We remember. Always have the habit of some kind of obstruction. What incorrect order was passed? That there is a dispute as to what procedure to be followed. There is a procedure under the law, whether followed or not. We call for the records to verify it. And you are again objecting to that also.
My intention was
Need not be sorry. You are just wasting time for a. Sorry?
The record maybe with my friend Lordship, that's something because already they put in the record Lordship on Lordship.
What is wrong with you? Okay,
I'm sorry,
interim withdrawn. List again. We'll hear. Just
Item 31.
May I please, it is matter, my lord, in the year 2018, my lord.
Yes.
There was an order passed by your lordship directing the respondent authorities to consider the case of the petitioner for provincialization under the 13(6) of the new act, lordship.
Under 13(6) of the 17 Act.
17
Mr. Chisti, what will happen with this writ petition?
It is a lordship.
No. What will happen? Will take up or
The registry has to lordship.
I don't know.
Yes, lordship. My registry should have lordship.
No. Everybody is saying everything else, but what to do? Should I take up or I should not take up? Take your call. If I want to take up, I'm ready to take up. If I should not,
yes, lordship may take up. Take it up. Lordship. Otherwise, we cannot take two stand lordship. In that case, lordship we have already taken.
no, that's why.
That is why.
What to do with all these matters? Why didn't you go and get a clarification from the division bench? What is to be done? File an clarificatory application that what is to be done.
There's another that special division when it was set for once lordship, and we had direct the registry to regroup all those cases lordship. For yesterday.
And how can you regroup?
That we don't know.
See, when there is something under law to be determined,
yes,
you can do it. Club it together, will determine the law, it will, everything else will follow.
Yes.
But these are all individual factual matters.
Yes, lordship.
What do you intend to do?
And here, lordship, I have received an instruction, lordship.
Adjourn to be placed before the registration. Sorry, we can't help you. Or else you get a clarification from the division bench order whether we should take up or we should not take up.
Yes.
Item 32.
It's almost now 3-4 months have gone by.
Gone by, lordship. And that special division is set for only once, lordship. It's not been sitting. And we're also in the dilemma, lordship.
And if you read that order, pending for decades. The reason is it is pending for decades. And bring a quietus. I think that's a language. But
these cases are not.
But this is of the 17 Act.
17
How
Act.
can it be pending for a decade?
Yes.
So whether these cases are to be separated,
yes,
those who are not pending for decades,
yes,
and taken up, or everything will be there.
Had the word repetition of single bench is not there, then also lordship, that was also there.
It is all.
And that's
So why don't you get a clarification?
Yes,
Get a clarification, tell us. If we are required to take, we'll take up. If we are not required, let be placed.
Obligatory.
Because repeatedly we are getting this request.
Yes.
One side will say to be taken up, another side will say other bench. And mind you, these are all simple factual determines it and nothing else. The schedule says how many posts are to be provincialized.
Yes.
It's very specific.
Yes.
If there is a competition for one post between two persons, you'll make a factual verification. Who is teaching that subject and who was appointed on which date, and take a call. And nothing more than that. If it is LP school, if it is high school, it is again different. Higher secondary, again a little different. That entry tax matter is different. There is one important question of law to be determined. So you club everything and place it before one. Once the law is determined, everybody will follow that. But here possibly factual determination, everything. We'll go on adjourning, or else you get a clarification whether we can take up or not.
Is it better to get a clarification from the honor?
If it is said no, we will not take up. If it is say yes, we'll take it up.
That I will do that.
32.
32. Yes, 32.
Actually, we have not filed the affidavit here, my lord.
Want to file? You, Sharma, for secondary.
Secondary education department.
Please, for 3 weeks time to file affidavit. Pray Lord. This
We have already filed an affidavit.
Your file. Respond for the affidavit. Respond for is already on record.
Lordship, matter is very simple, Lordship. Without B.Ed degree, the respondent number 4 is holding in charge headmaster. Lordship, you have.
Do you have any interim order?
I have no any interim order. Lordship, kindly look impugn order, page number 29. Kindly look, Lordship. It's a very simple.
Mr. Sharma, can we hear this matter? Then he says simple matter.
Very simple matter.
Your affidavit is not required.
No.
See, you take your call. If you want us to hear the matter, it is materials are enough to be heard. We can hear it. Required. He says the affidavit is required.
He has graduated, my lord, 8 to 2023, my lord.
For he's a in-charge principal of a high school.
Yes, my lord.
And what is the qualification required? Graduate teacher.
Yes.
Where is the qualification of a principal headmaster of a high school?
Actually, as per Rule 14(2), surplus Assam Secondary Education Provincialization Service Rules, 2018.
2018. Which rule?
B.Ed degree is mandatory.
No. Which rule?
14(2).
14(2). Okay.
That's 36.
He must be BA, BT degree from any recognized. Must have 10 years teaching experience as graduate teacher. This is an amalgamated school or it's a high school? High school.
It's a high school.
All along it's a high school. Are you a graduate teacher?
And yeah, Lordship, I am a graduate teacher, Hindi teacher.
Why? No. Provide he must have 10 year experience as graduate teacher.
Yes,
Are you
Lordship,
a graduate teacher?
Yes, Lordship, I have been receiving full graduate scale pay with effect from 1/1/2013. Can you look, Lordship, page number 27.
What is a graduate teacher?
Graduate teacher, Lordship.
How does the rule define the graduate teacher?
Lordship, as per Guwahati High Court judgment.
Not her judgment. How does the rule define?
For being a headmaster or permanent headmaster, Lordship, there's a need to graduate teacher.
Who is a graduate teacher, Mr. Sharma?
In the rule 17, it is mentioned. Rule 17, it is mentioned.
Rule 17. Graduate teacher.
Yes.
Graduate teacher means and includes the category of assistant teacher, category so and so and so. Top higher school, including amalgamation. For whose appointment the minimum qualification is graduate in arts. So, where is your appointment order?
Lordship, kindly look page 27 and Annex 7.
27.
As per the as per recognition of the 194, the incumbent Anil Tamuli and Hindi teacher, date of joining 16.
Anil Tamuli, Hindi teacher. 12/13. This is provincializing. The following have been provincialized. It's not appointment. Anyway, provincialized under the Act of 2011. Mr. Sharma? Provincialized under Act of 2011.
No, my lord. It is 2000 school.
What? No, I think it is yes. It is 11. What was the qualification for a Hindi teacher under the 2011 rules? Because graduate teacher is defined for whose appointment the minimum qualification is graduate. So, if his appointment is by provincialization, what was the qualification for appointment of a Hindi? Was it graduate or it was something different?
Graduated in the year 2023.
Doesn't matter. The graduate teacher definition is for whose appointment the minimum qualification is graduate. So, if for that appointment minimum qualification is graduate, he is a graduate teacher.
Lordship.
It nowhere says when he will attain the graduation. So now what is the qualification for a Hindi teacher when he was provincialized in 2013?
Lordship.
Since when you are getting graduate scale of pay?
Yes, 1/1/2013.
That is after this order.
Lordship, kindly look the senior
as on 12
Annex 9.
As on 12/8/2013, what was your qualification?
Lordship.
What was the qualification of Anil Tamuli on 12/8/2013 when he was provincialized?
Lordship, as per government notification passed by the.
Mr. I am asking you a question of fact, not on the question of notification. What was your qualification?
Lordship, Hindi BA,
Hindi,
Ratna, and
Hindi Ratna,
along with Parangat, equivalent to BA Lordship, which is recognized by which is.
So Hindi Parangan qualification is also a
BA
graduate qualification.
Lordship, Parangan is equivalent to BA Lordship, and Ratna is equivalent to BA as per government notifications dated 1979, which
Page
is passed by Deputy Secretary.
Page number.
Lordship,
where is that notification? Page number?
Yes, Lordship, that notification is reflected in a DV order, which is filed by you, Lordship, in this court.
It's not question of you and me here.
Lordship,
it's not any personal relation we are exercising.
Lordship, there's a specific order reflected in the
We
order.
want to see where is that provision. Where is that provision saying Hindi Ratna is equivalent to a degree of graduate in arts? Please let us take a look at it.
Under 2003 rule, page 388. Proving this Ratna in Hindi with 50% marks, having degree qualification from any recognized university, or BA with Hindi as one of the subjects.
So you need a regular graduate degree also. Okay, we'll have to hear you in detail. Mr. U. Sharma, then counsel for the respondent to file the affidavit as paid for. We cannot pass any interim order today. We examined it. Yes, next item.
That may be fixed.
Yes. 33, 34, 35.
Those TGL, ex-TGL matter. We have already passed one order for medical. We want to do it in phase wise. Medical has some time limit urgency.
In fact, your lordship's order is a very detailed and very lengthy order, which has been absolutely covers all the required essentials of how they are required to produce and what certificates they are required. We are absolutely fine with that order. The same order is adapted or passed in our cases. I have no difficulty. Subject to what the petitioner.
Yes, any submission you want to make?
Lordship, only one submission, Lordship. I have got some instruction in the government of Assam. There is a website of the government of Assam in where they apply the online certificate.
See, websites are facilitating process. Websites are not determination of any law.
No, Lordship, I'm saying something different.
What do you want to say?
In that website, the columns has been provided. In that column, Koiri, Nunia, all this have been provided. In that website, the TGL, it has been provided separately, TGL column, and within that column, Koiri and Nunia is provided, and Koiri is again provided separately. So,
sorry?
Koiri is again provided separately.
What is provided separately?
Koiri community.
Koiri community.
That is provided separately, not included in TGL and ex-TGL. So whether
Mr. Counsel, we will go by the notification issued by the government of India, not website. Websites are means of attaining something. Websites never determine any law. If websites determine law, the world will be in a chaos. If you go to the internet and go into all the websites, all kind of materials are there. If everything is converted to law, the world will collapse.
I understand.
Bottom line is, law is determined by the provision of the law, not what may be indicated in any website here and there. Whether Koiri is a OBC or not will be determined by the 1993 OBC notification of the government of India, which has enlisted which communities will be OBC in the state of Assam, again, mind you, not as a whole. There, amongst the entries which are recognized as OBC, Koiri is not included. Koiri is included only as possibly serial number 25 under clause 24. There, before being a Koiri, first you will have to satisfy you are a TGL. Only the second line of consideration is query or not. This is basically, we have already given a detailed hearing. I don't know whether you were present or not that day, but it was done in the presence of everybody.
I have the order.
Lordship, the other order, Lordship, those are related to medical admission. So because of the timeline, Lordship has fixed.
Definitely. So medical has to be done before 30 September. So we give preference to medical.
So now Lordship has
Once
seen,
the medical is over, we'll go for all
then
other
we'll go
all
for
others.
that is what Manoj, I would like to indicate. Already the committee is Lordship has already seen.
What I'm told this morning that
Yes.
the committee is already started its function.
Verification has started from 9:30 on today. So on 26th, the matters are again coming. After that,
So this one
will
also, once we get the information that the medical are over, we'll adopt the same order in these petitions and adopt the same process.
Yes.
If I passed the order today, the committee will have a little difficulty because they don't know whether to do this one or the medical one.
Correct.
So we wait for some time.
So after the medical admissions,
As per for list on 26,
27.
27, list on 27, along with the other ones. Couldn't get that. Okay, we'll list in the first week of October. In the meantime, medical will be over.
that will be over because 30 is the last day. Lordship.
5th October.
Fifth.
And medical order was heard after hearing everybody, not only medical confined.
Yes.
It was heard, everybody was heard in that.
I'm sorry, I could not present for 4 days before.
No, we are not on your personnel.
No, not
but it was heard after hearing
Yes.
all the parties,
Yes.
medical as well as non-medical.
Yes. Because of my illness, Lordship, I could not appear for 4 days, Lordship.
36.
That's why detailed hearing.
I'm obliged.
Yes.
Please, my lord.
Dr. Sharma.
Here, ME Madrasa schools of Dhubri district, my lord. We were beneficiaries under the PM Poshan scheme, my lord. The erstwhile midday meal scheme, which provided us with 1 rice meal per day.
You need an affidavit or you don't need an affidavit?
My lord, on the last occasion, they submitted, they will file an affidavit.
No, last occasion it came only once when notice was issued. There's no subsequent last occasion. So what do you say, Mr. Phukan? You want to file affidavit?
I'll file an affidavit, Lordship, for the elementary, but for the SSA, most probably Mr. B. Gugoi will.
Both Mr. B. Gogoi and Mr. A. Phukan, respectively, for the SSA and the elementary education, have placed for 2 weeks time to file affidavit. We're allowed list after 2 weeks. Not 2 weeks, 4 weeks. List after 4 weeks.
Highly obliged.
37.
Yes, Madam Devi.
And in this case, I have filed one IA.
I need some
Item
time
number
to
61.
IA for what purpose?
61.
Oh, vacating.
Vacating,
61.
vacating.
Today, for the first time, it is reached. So I need some.
He
time
would like to file.
This is item 37.
That 61. I think
61 is I. It is separately.
Yes.
Together, yes.
60.
Fix this matter on 10th, my lord. He wants to file objection. But no objection is necessary. I have not been received salaries, my lord. Because of.
How do you appear?
I am for the petitioner, Lord.
A writ petition.
Yes, Lord.
You have obtained some stay order.
Yes.
Case of provincialization.
No, Lord.
No.
For, yeah,
It's an appointment of headmaster.
Go to the other place.
Appointment of headmaster. Actually, what happened, my lord, in this case?
So your appointment is challenged.
Yes. He challenged.
As per for list on so 61 of the same item.
10th.
61 of Khali Divo, Mr. E. Deka for the place for an adjournment to file a reply in the interlocutory application.
Obliged.
38 for orders.
Time being, Mr. K. Gogoi has decision instruction.
Time being.
I say already. How about 39.
Yes,
Last
Mr.
order, kindly be
Losco.
produced, my lord.
Sorry.
Last order.
Although last order lordship that day I was appeared and it was listed before Honorable Chief Justice lordship to submit a compliance report, but the petitioner lordship he has not taken steps upon the response to till that lordship. Though notice was issued on 21/9.
Just a minute. What
Office
is
note
this?
lordship can pay office note at 4 to 23 lordship.
Just a minute.
Notice was issued on 21/9/22 and office note dated 4/2/23. He has not taken any step till date, Lordship.
How many respondents are there?
Only two respondents.
Then what is this order? Neither Ediga nor is he in respondent notice issued to the sole respondent.
Because Vijay Chaudhary law, she is not in service because she
Okay,
suffered-
initially sole respondent, subsequently the new incumbent was
and
implemented.
he has not taken step till that.
No, my lord, on last occasion, when matter was posted before court number 1, my lord. As he submitted, he appeared for both respondents, my lord. I have submitted, even furnishing the copies of the.
What you have furnished?
On last occasion, when matter was posted before court number 1.
No.
He submitted that he is appearing for both the respondents, my lord. And that's why I have even extra copies.
No, you can't do that. Contempt cannot be done that.
It was not my submission, but your honorable court has asked me to appear, Lordship, because as I was appearing in another cases, Lordship.
But there is only one respondent.
Yes.
From where does the second respondent come from?
Subsequently, he was
I think he is implemented. I think.
Sorry?
There is an order, Lordship, 21/9/22. Lordship, can
21/9/22. IS civil.
Yes, Lordship.
Okay.
He has included. He was supposed to take steps.
Where is your steps on respondent number 2?
Now, my lord, on 12/12, when the matter was posted before the court, my lord, as he has submitted before the court, he is appearing for both the respondents, my lord. That's why
I didn't.
How can he appear? It's a contempt.
My lord, then I may be allowed to take steps.
Take steps.
My lord.
Yes.
Contempt we cannot impose on anyone.
That is the difficulty.
Contempt sometimes we make a request for a different purpose.
Yes.
If we intend to dispose it of requiring them to do something,
Yes.
we want some information whether we have done or we have not done.
Exactly.
But contempt is always the prerogative of the contender to engage any advocate they feel like. We cannot impose it on. Although ultimately it will be Mr. Chisti only who will represent.
Yes.
But it cannot be from our side. A petitioner to take steps for service on the respondent number 2. List again.
I am sorry, in item number 37, interior that may be continued also.
Did not submit at that time.
Is the law of acquiescence applicable? Acquiescence and waiver.
I'm sorry, but I forget. Still it is obliged.
Item 40.
40, who is appearing? NJ Khatonier, he was here. I think, oh no, you are for the respondent. Right, compare issue notice. Petitioner to take steps.
Anyway, time to more issue already. I have already communicated.
39 and 40.
Again, this is the same thing.
Same thing, actually. Exactly same thing.
Can it be done?
No, otherwise.
The petitioner to take fresh steps on the respondents in their present and correct address by registered post within 3 days.
41.
Although there is an order dated 1/2/2023 that Mr. NJ Khatonier Learned Counsel would obtain some instruction and file wakalat number, but it is noticed that the notice of the contempt is yet to be served on the respondents, and nor Mr. Khatonier is authorized by the contempt respondent containers to appear. None appears for the petitioner. Mr. Khatonier is given the responsibility to inform the land council for the petition of the order passed.
41.
Take the responsibility. Yeah. Take it, but yes, Mr. Purokar.
As per office note, my lord, neither
Till
the
date, no application for impleadment.
impleadment I could not file, my lord. But respondent number 2 has.
You want to implead?
Respondent number 1 is newly appointed, new
No,
incumbent
no.
has come.
Do you want to implead or you don't want to implead?
I will implead the
One.
respondent number 1.
Do you want to file application or you
Yes,
don't
sir.
want? Mr. B. Purokar, land counsel for the petitioner states that the present incumbent, who is that? Respondent number 1?
Respondent number 1, earlier, my lord, Dr. Vijay Chaudhary.
Not
now,
the name, the designation.
No,
The present
secretary to the government of Assam.
incumbent secretary to the government of Assam in the school education department. Is sought to be impleaded as a respondent contender, and the land council requires some time to file the appropriate application adjourned.
42.
IA.
I, my lord.
I
I have
what?
filed IA, my lord, for packeting the order.
Packeting the yes.
Lordship, I am appearing on behalf of Mr. BK Das, Lordship. He is not well today, Lordship. So kindly matter may be taken
next week, my lord, because
It is stated by MS
J. Kolita.
J. Kolita Land Council that Mr. BK Das, Land Council for the writ petitioner, is unwell. List again.
29th. 43.
Yes.
Lordship, notice was already served upon the sole respondent. It is reflected in the order dated 22/8/2023.
43 notices are served. This is contempt petition. Petitioner to take fresh steps on the respondent contemners, inasmuch as the Lajima court order is on the basis of some postal track consignment rather than a satisfaction of actual service of notice.
44.
You cannot send a man to jail without proper service. It's a contempt petition, not a writ.
Lordship, office note 29/9 shows date.
Sorry?
Office note dated 29/9.
29/9.
Neither Redicard nor answered notice upon the sole respondent. And
When were steps taken? Notice issued on 16/6. Await service report with reference to the office note dated 19/9/2023. Or you want to take fresh steps?
My lord,
Your choice.
My lord, I may be allowed to take fresh steps.
Fresh steps.
Sure. Petitioner also allowed to take fresh steps on the respondent by registered post.
45.
Yes, please, Lordship, as per office noted dated 19/9, service is not completed.
Service. Await service report as with reference to the office note dated 19/9/2023.
46.
40 years.
Lordship, may kindly see the last order, my lord.
Heard Mr. D.K. Purokar.
Dated 15/9/2020.
Yeah, that's the order. Heard
Yes,
Mr.
my lord.
A.K. Purokar.
3 days were allowed, my lord, to pass a speaking order, my lord. There is a non-compliance, my lord, of the direction of this honorable court dated 30/8/2023.
I heard MSSB Chaudhary, Land Counsel for the petitioner, also heard Mr. P. Saikya, learned Junior advocate, who can also appear for the Deputy Commissioner Sonitpur. This contempt petition is instituted alleging willful and deliberate violation of the order dated 30/8/2023 in WPC 4510/2023, the operative portion of which is extracted as below. It is noticed that there is a direction to the Deputy Commissioner Sonipur to pass a revision order on the application of petitioner for a non-criminal certificate for the OBC category, where such request is made for the purpose of admission to the medical colleges in the first year MBBS course to the medical colleges in Assam. It is taken note of that the last possible date for admission is 30/9/2023, and therefore there is an extreme urgency on the part of the petitioner. The Deputy Commissioner is directed to consider, and have we done it?
Consider.
Then why are you not waiting for it? In response thereof, the Deputy Commissioner had informed Mr. P. Saikia by communication dated 21/3/2023 that the application of the petitioner was given a consideration. But as per the materials in the application, it was noticed that the annual income of the parents of the applicant is more than rupees 8 lakhs per year. And therefore, a non-criminal certificate cannot be granted. Accordingly, we see no further requirement to keep the contempt petition pending, contempt petition closed. However, if the determination of the Deputy Commissioner is incorrect, liberty remains with the petitioner to assail the same. As no order of rejection is produced by the court, other than the communication of the Deputy Commissioner dated 21/9/2023, a copy of the same is handed over to the learned counsel of the petitioner, and if advised based on the information contained in the said communication, the petitioner is given the liberty to approach the court again if so advised. Order again, you have to wait for 2 more days. If you want, directly challenge it so that we can take it up before 30.
7.
This is a contempt petition, my lord, page 9. First time. Operative part.
Is there any direction?
Yes, my lord.
Yes. Was it communicated?
Yes, my lord.
48 to 51.
This was an IA file for amendment, lordship.
IA file for
amendment of the petition, lordship, that last occasion, lordship.
What kind of amendment? Because amendment, I'm frankly speaking, Mr. Dekka, I'm a little skeptical. Because amendment is a huge process. Plus, the law is very circumscribed. Why do you want to amend? Did I hear you earlier?
Yes, lordship.
Now, what do you want to do?
Lordship, lordship permits, I would file a new petition. But lordship,
I don't know. If you
in this case, what has happened?
If you ask me, I always feel a new writ petition is a better option.
Yes, lordship.
Because these are not civil cases. Amendment is a concept of those title suits. Because where you have no scope of withdrawing and refiling and all those, taking all those things.
Look, I also feel that, but only thing is that, lordship, these cases after this case.
And it's a writ petition of which year?
2017.
Oh, 17.
After that, so many cases have been filed, which is arisen out of this writ petition. Lordship, that is why I was skeptical not to file a new writ petition, because all
17 writ petition. What is the writ petition about?
This is a writ petition whereby I was removed from the position of a headmaster, and my salary was not paid. And then
now, your 2017 writ petition, you are removed as a headmaster and salary not paid. And the later writ petitions, why they were filed?
They were filed because, lordship, after passing of an interim order by this honorable court lordship, I was removed from the service, removed from the post of headmaster.
There is an interim order
Running
saying
in-
the removal.
Yes, Lord.
In spite of that,
In spite
again
of that,
review.
yes.
For the same reason or different reason?
For the same reason. Subsequently, there was the director has been called personally, lordship, and then he said that there was some miscommunication, and then they came.
So now you were in service.
I mean, right now.
Presently, you were in service
Yes,
by
Lord.
virtue of interim order.
Yes, lordship.
Now tell me, why do you want to file an amendment?
Yes, lordship. The director of the director came lordship in person appearance, and he took a stand that my appointment is fake and my appointment letter could not be placed out in the department. Now there is a specific query from this honorable court that whether you have filed any complaint or petition or have you ever issued a show cause notice or anything, and the director could not say anything. On the very next day, he filed a police complaint. And that complaint, there is no case number, and only GD entry is there, and that only that was
So
there.
therefore, you want to amend.
Because I have to basically
No,
challenge
just so therefore you want to amend.
that challenge.
So you also want to challenge the police complaint.
No. That action that whereby he has said that.
No. You say next day he filed a police complaint.
Yes.
Do you want to challenge the police complaint?
No.
For passing out a police complaint?
Because their stand is that my appointment is fake. That's what.
No, we understand that. So now, amendment. Why do you want an amendment?
To incorporate the fact that my appointment has been declared as fake, and I want a amendment against that lordship.
Where is the declaration?
Lordship may kindly see.
So where is the declaration and what is the date of that declaration?
Lordship.
You say your appointment is declared to be fake.
No, not declared to be fake.
Just now you said declared to be fake.
In the affidavit, subsequently they have filed an affidavit, and in that affidavit they have stated that my appointment.
No, that is a stand they have taken. That's not a declaration.
No, that's not a declaration. That is
every stand taken in a pleading is not a declaration. We'll determine whether that fact is right or wrong.
My lord, but then they filed an affidavit stating that my appointment is fake, lordship. So, lordship, I want to incorporate that in my 2017 writ petition, because if I am not able to prove that, my entire case will go, and that is the reason why I have.
You don't have to do all these things, Mr. Dekar. We'll hear you. Start your hearing. We'll hear you today. Yes.
Today, my lord, I was not ready, but anyway, I'll try my best.
Be ready on whatever day we'll hear you. Then we'll think about whether amendment.
Yes,
because amendment is a difficult proposition. Why you know? You can bring in an amendment to a pleading of a fact which could not be incorporated but existed on the day of the filing. Say you missed it out. Now it appears you want to file an amendment of a fact which has subsequently arisen. Suppose I allow the amendment. It will be a writ petition of 2017. You want to incorporate facts of a later fact.
Yes.
Is it possible to conceive that fact being incorporated in that writ petition in 2017 when the fact did not arise at all?
According to
think logically. Then how can you amend it? After the amendment petition is complete, it is supposed to be depicting fact as it should exist when the petition was filed. If the fact, occurrence of the fact is subsequent, how can a future fact be incorporated in a petition? Therefore, we are little skeptical of this amendment or not. But your problem we can take care of in a different manner. If your apprehension is just because they have taken a stand, it is fake. Therefore, you have lost out everything. You don't worry. You will take care of the problem. Not by virtue of an amendment, but some other means.
Then this matter is fixed for hearing.
So therefore, let us hear you.
On a date, lordship may be fixed.
Never. We're keeping it open. Your application also. We are not dismissing it.
12th October. 12th October.
On who appears for the response? Are you ready? Can I hear the petition today? On 12, can I hear it? When it will be listed on 12, can I hear it? No. Yes. List on so and so as a key. And then endeavor shall be made to give a final consideration, considering it to be a repetition of the year 2017. The respondents to also produce the records based upon which the affidavit had been filed that the initial appointment of the petitioner
in the year 2009.
Dated
23/9/2009.
23/9/2009 is a false and fabricated appointment. Because it is your stand, burden is on you to prove it.
I love it.
52.
In the first title of the repetition, in the main repetition, Your Lordship, the name of the repetitioner has been written. Yes.
So the certified copy you are getting under a wrong name.
No, Lordship. In
So
the
why do you want
main
to-
repetition, in the first title, repetition's name has been written as FAK. It should have been FOK.
Very well, we understand. Why do you want to change?
Repetition is pending.
That's a pending repetition.
Yes. Main repetition is pending.
Heard
RHOD.
learned counsel for the applicant. Also heard Mr. Ganesh Peku, learned counsel for the elementary education. By this interlocutory application, the first title in WPC 945/2023 is sought to be amended to the extent that the name of the petitioner should be read as Fokrun Nehar Roston, FOKRUN, instead of Fokrun Nehar, FAKRUN. It stated that the correct name of the petitioner is, in fact, Fokrun Nehar. In view of the law, I allow the first title in WPC depicting the name of the petitioner be now read as Fokrun Ali Roston. Raised to make necessary correction in the cost title as well as in the CA system.
53.
Yeah, Mr. Lordship, my lord. Last title, my lord, 38/2023, my lord, Lordship has passed the order for taking the dusty service upon the respondent number 3 and 4 and to produce the record on today.
Agree to the access selection process pursuant.
This is I have filed the affidavit, my lord. I have, my lord, filed the affidavit of completion of dusty on my lord 18/9.
Okay, we have filed. Or respondent number
3 and 4, my lord.
3 and 4.
Yes, ma'am.
As provided in the order dated 38/2023, it is stated by Mr. P. Mohanto, learned counsel for the petitioner, that steps through dusty method had been effected on the respondents number 3 and 4. And to that extent, an affidavit dated 18/9/2023 has been filed, enclosing a copy of the notice which contains the endorsement of the principal of BP Chaliha College as regards the receipt of notice. In view of the above, service on respondent number 3 and 4 accepted. None appears for the respondents number 3 and 4. List again on so and so for further consideration. I think you are protected interim.
It is protected not to take the further course of action, my lord. And they were directed to produce the record, my lord. They record the fee. Lordship said that on the produce of the record is nothing is there.
Let them appear only when the records will come.
My lord. Master.
Item 55 for motion.
May I please have the lordship? My lord, this is the yesterday's matter, my lord, that regarding dias correction, and we have filed an affidavit. My lordship was pleased to direct us not to file an affidavit that the what sort of police action has been carried out.
Oh, the police action.
My
huh?
lord, my lord. My
Where
lord,
is the affidavit?
my lord,
Hmm. Have you preserved this call details?
my lord, my lord, it will be available.
Suppose we want to
Yes,
ask
yes,
for it, you
yes,
can
yes.
produce it.
Yes, my lord, yes.
What is the original writ petition for?
My lord, that the dias data, my lord, record Wasel Ali and Wahed Ali.
No, why all these people?
My lord, I don't know, my lord. My lord, if they want my appearance, my lord,
It's
I can go.
have you gone through the affidavit, Mr. Saikia? It's a serious allegation. Why? What business the circle officer, ADC, they have? It appears to be a inadequate writ petition that my correction is required in the dice data. Court will take it up.
That correction part will be, my lord.
It will be done by
the
somebody.
legal
Why
member
is the
for
ADC
assessment.
interested in this man?
My lord, as per the telephonic inspection with the ADC, she informed me, my lord, that in the
Who is
present
the
case, my
ADC?
lord,
Lakshmi Dutta?
Lakshmi Dutta.
What is
Some
it?
document was required. Therefore,
Some
documents in regards to the.
Why does he want document?
My lord, because
Is
my
he
lord,
making any inquiry?
no, my lord, there is
No,
there
no.
is a earlier
ADC
court
cannot
order,
ask for document at random from anybody. Why does he want a document?
SSA, my lord, they have in this matter, my lord, SSA director, he was Soko's matter.
Who?
SSA director, SSA.
Director SSA?
Earlier matter.
So caused by whom?
Supposed by this honorable court regarding the probably his date of birth is wrong, my lord, and name was also wrong.
No, no. Where did he issue
Therefore,
Sokos
my
to
lord,
director? Please show us which order. By which order we issued notice to the director?
The very first order passed in this petition, my lord, in this order dated, my lord.
Where is that order? 19/10/2022.
My lord, is it page
1910.
page 63, my lord.
63 to 67.
Annex 9 to the writ petition.
So special duty officer has come forward before the court and made a statement that she was unaware of the earlier High Court order. So that's the end of the matter.
My lord, in this regard, my lord, director SSA requested the additional deputy commissioner to bring some document from the petitioner. And therefore, my lord,
Why
the
this
ADC
extra constitutional method? See, Mr. Saikia, who appears for SSA?
B. Gogoi, my lord.
Let have Mr. Gogoi. See, director is a respondent.
Right.
If in course of the hearing, director feels that there are some document with the petitioner, he wants it. What is the provision of CPC? Documents in the custody of the other side. There's a particular procedure is there.
Procedure is there.
He'll invoke that procedure and ask for the documents.
My lord, being
Why will he use this extra constitutional method through all these senior district officials? Threaten these, go to the father-in-law in the night time. What is this?
part, my lord, I have no knowledge.
See,
of
we
that
are
part,
finding it a little difficult.
I specially asked you that question, my lord, why you are interested to call this document. Then she
Let
said,
everybody
my lord,
come.
district scrutiny committee, my lord.
No,
The
let,
report is available with
I don't
them,
know.
sir.
The merit of the writ petition will be decided
My lord.
in a different way separately.
My lord.
As the conduct of the some senior officials are brought to the notice of the by means of an affidavit. That's why you required him to file an affidavit yesterday.
My lord.
That we are not going on oral statement,
My lord.
file an affidavit. Affidavit is on record.
My lord.
How can we appreciate the conduct of the senior district officials of this behavior?
My lord.
This behavior appears to be adopting some extra constitutional method.
My lord, in this case, my lord, may please allow us 10 days time, my lord.
We will not allow
My lord.
anything. We will not allow anything. We are going to take it up right now. This is a matter from which district?
Borpeta. Borpeta.
How long it takes to come from Borpeta?
2.5, 3 hours.
Sorry?
2.5, 3 hours.
3 hours. Ask everybody to remain present at 10:30 on Monday. If it takes 2 hours, ask him to come by 4:15 immediately.
The police part, my lord, she has
Sorry?
not, regarding the police part, my lord, she has not disclosed it.
Who?
Additional deputy commissioner.
What
She
not?
said that I
Not
send
she.
it-
I think it is he. Lakshmi, Lakshmi is a lady or a gent?
Lady, my lord.
Lady.
Lady, my lord.
Okay. Why? Yeah, see the allegation. Have you read it?
My lord.
One in para 3, it's very serious.
My lord.
Wazadul Hussain, programmer MIS block, informed the petitioner from him to appear before the ADC. This is extraneous. With all records before 21/9. Why does the ADC require any record? What record?
Regarding the petitioner dice record.
Why do you want?
Because, my lord, they are.
The High Court is deciding or the ADC is deciding? Did you ever ask the ADC to inquire into it?
No, ma'am.
Number one.
No.
Wanted to know from Wazadul, he threatened the petition if he does not appear, police action will be taken. Why do you threat? Who is this Wazadul? He's a government employee? Government employee?
My lord.
What business a government employee has to threaten the citizens? 3. He said, rightly taken the stand. He requested Wazadul to issue a notice of appearance. Yes, you issue a notice, I'll go. But Wazadul says, no notice, nothing. Come over. It's a high-handed manner action. Therefore, SDC come Circle Officer Mandia, that name, along with village headman and police of Mandia, came to the residence at 3 p.m., 4 p.m., 5 p.m., 7 p.m. at the residence of father-in-law with an intention to pick him up. What authority they have?
Absolutely, my lord, they have no.
What authority under the law you have to pick up a man by bringing the police?
Administrative power.
Police is acts under CRPC, not at the whims of all these officials. Why will you pick up? Is there any case registered?
No.
Then ask everybody to come personally. It cannot be taken lightly. Moreover, when it is intricately connected with a pending petition before the court. As the petitioner, the same. Today around 1 p.m., circle officer called the father-in-law and treating him of police action. What is this? When the matter was taken up, Khalid to Depot, an oral submission was made by Mr. E.R. Bhuya, land counsel petitioner, that the writ petitioner needs some protection in as much as certain senior district administration officials are threatening him. In the circumstance, we require the petitioner to file an affidavit stating the circumstances based upon which it is stated that he has been threatened. Accordingly, an affidavit dated as it date has been filed. The paragraph filed and paragraph 3 and 4 of the said affidavit is extracted as below. A reading of the contents of paragraph 3 and 4 of the affidavit makes it discernible that certain senior district administration officials are adopting extra constitutional methods for whatever reason against the petitioner. The additional deputy commissioner, what, Borpeta? Naam to likhi dibo. The subdivisional officer, the subdivisional, the circle officer, so and so, the village headman of Hotrok Kanara Gaon, the officer in charge of Mandia police station, to remain personally present before the court on Monday. Mr. P. Saikia, land counsel appearing for the additional deputy commissioner, makes a statement that the said actions were taken by the additional deputy commissioner on the instruction of the director of, where is the SSA counsel gone? On the instruction of the director of? SSA does not have a director.
Mission director.
Mission director.
On the mission director SSA, the mission director SSA to also remain personally present with all relevant records, documents relating to their actions as recorded above.
My lord, this headman, my lord, he may be
Whoever it is, Hotora Gaon. If the police can go and disturb this petitioner, police can also find out who is the headman and bring him here. Your name of the village is indicated. Why they are behaving this way? Is there a rule of the jungle prevailing or the rule of a civilized society prevailing here? Have you noticed? Have you read it?
My lord,
don't you think being an officer, it's a very, very serious?
Even I asked her in a field, my lord, on that extent that we have not taken her.
No, even if it is justified, can you do it? Being a responsible officer of the government, can you do it? Even if it is justified?
Any requirement even seek an
if he is a hardened criminal, go and file a FIR against him if he had done something. Take action. No one is going to prevent you. But what is this?
Even as per my understanding, even seek an issue a notice on it because it is administrative.
Notice also why? Why will you issue a notice for nothing?
If some document is required, matter.
Why do you need why do you need a document? If you are a respondent in a pending petition, you feel you need some documents, it is in the possession of the other side. That relevant provision of CPC will be, what is it? Order what? Let's find out.
Provision of notice,
Not notice.
Huh?
14.
I'm not.
When the document is in the hand of the other side,
Mine.
there is a provision of making an application to the court to require the other side to produce those documents.
Yes, order 49.
Maybe 40.
Production of documents.
I think it will be those will be applicable. Not that you just send the police and bring him somebody. And if you don't come, in which direction are we heading, this country? We want the presence. This is too serious an allegation. If you defend it, I don't know how you do, but
My lord, may I prepare a copy of this?
a copy of the order, Mr. P. Sai.
Much obliged.
And Mr. Saikia, ask your officers not to harass this person any further. If you get some more information regarding something done after this order, you'll be in further trouble. Tell them.
My lord, that as yesterday I have already indicated.
It's further directed that none of the aforesaid officials shall harass or intimidate the petitioner in any manner.
Obliged.
And if any report is received, appropriate action will be taken.
Obliged.
May I please? My lord, this matter pertains to compulsory appointment. Page 12 is my application, my lord.
No, was it placed before DLC?
It was till that we have not been communicated, my lord. They received the application.
Mr. Ganesh Peg was same order. Same order as in the morning. If not placed, you placed it. If placed, inform him. Yes. And secondly, you verify from the records whether there is any pending application or not. If not, you inform him. Which district? Karimganj. Karimganj DC, Mr. Ganesh Peg for elementary. Yes. The father of the petitioner, Sushil Ranjan Chanda, is stated to have been working as a LP school teacher in which school? In the 1200 Lama Dimpur LP school in the Karimganj district, who died in harness on 11/2/2012. It is also stated that at the time of the death of the father, the petitioner was a minor, and upon attaining majority, he had made an application for compassionate appointment on
10/7/2014.
10/7/2014. The grievance raised is that a said application had not been placed before the DLC concerned as required under the law. Considering the limited grievance raised, we direct the District Elementary Education Officer Karimganj to place the application petitioner for compassionate appointment before the next available DLC for its consideration on merit. It is provided that in the even the application was earlier placed before the DLC, the respondent shall inform the petitioner about any such order that may have been passed, and in such event, there would be no requirement to again place it before the DLC. Further, the respondents to also verify from the records as to whether any application dated so and so for comment had been made by the petitioner, and if the records reveal that no such application is there, the petitioner will be also informed accordingly. And in such event also, there will be no requirement to place it before any DLC.
If
Both
not,
of India options.
if not placed, that may be placed, madam.
We have already provided that.
Published.
We have also provided if there is no application, no request.
Published.
Mr. Here. Assam University.
May I please as a lord? My lord, both the petitioners are graduates under the my lord stream of my lord Bachelor of Vocational Courses, my lord, which the Assam University Silchar is operating. My lord, what has happened, and they have another scheme under the university that my lord, those
Just a
persons, my
minute,
lord,
to display the merit list for admission to BTech lateral. You are applied for that.
Yes, my lord, we have appeared in the entrance examination, which is required, my lord, to get admission in this BTech in a lateral mode. But that entrance examination result has not yet been declared. And my lord, this session is almost going to be started.
Ask the university.
May I submit? I've already obtained instruction. 4 persons applied for the course.
No. Ask the university, scan the merit list for BTech lateral, send it by email to the court. We'll take it up after some time.
Let's see what happened. Actually, I talked to the registrar also.
So instead of going for oral submission, let us look at it. It'll hardly take 10 minutes for you.
Just for Lordship consideration, their candidature was not, they were not found to be eligible. And they were individually informed about that they have not been.
No, you produce that also. The individual information given, the merit list, because his prayer is display the merit list.
Result was not declared.
Just a minute, Mr. Kia.
Yes.
Prayer is display the merit list. We'll procure the merit list from you in this given manner and display it before him. The prayer is met. It's a best course open for you. Nowadays, scanning machine is available in every office. Even we have one here.
I'll ask them to.
Scan it. A court email address to DDO, court email address, or your personal email address. Give us a copy.
Within 10 minutes.
If your grievance is met, it's okay. Why should we again bother?
May I take a lordship? My lord, the petitioner before lordship has challenged Annex 6 impugned order, my lord.
Today, what is to be done?
My lord,
anybody want to file affidavit? State respondents, you intend to file affidavit? Director of Secondary Education, District Development Commissioner. Who is he? District Development Commissioner. Is it Education Department or district? Want to fight?
My lord, will file.
Both Mr. P. Saikia for the Deputy Commissioner Kachar and Mr. SMT Chisti for the Secondary Education were praised for 3 weeks time to file affidavit of trail or just after 3 weeks.
a date may kindly be given.
Okay. 60 is not the date. 60 is not the date.
Yes, sir.
Date will be given.
I understand, my lord. Obliged.
Moment he says 60, you look this side.
May I please, Your Lordship? Your Lordship, as per the order of the
No, affidavit file.
Yes, Your Lordship, I have filed.
Pleadings over.
Yes, service of notice is complete, Your Lordship.
No, is it ready for hearing? Can you hear it?
Your Lordship, I need to submit, Your Lordship, that respondent number 5 has already filed an affidavit in opposition, but the respondent number 5 could not have traced me out, so a copy of the additional affidavit in opposition was to be served in the court, Your Lordship, today, Your Lordship. But
so you are ready to receive it today?
Yes, Your Lordship.
So today you are traceable?
Pardon, Your Lordship?
Today you are traceable. Earlier you were not traceable.
Actually, it has been stated in the notice, Your Lordship.
Yes, so for respondent number?
5, Your Lordship.
5. Who appears first one?
5 is a person.
Give the copies. Why do you need a court proceeding for all this? You could have easily given to Mr. Dekar. And I don't think he will be untraceable. If you make some effort, definitely not. We don't believe that. You could have easily called him, say, where is your presence? I want to serve a copy. Anyway, the copy of the affidavit in opposition of respondent number 5 had been served to the petitioner. List again.
Yes, much obliged.
Much obliged. 62. Yes, Mr. Bhuya.
Lord, service report is awaited. My lord, a small mistake we have detected.
Sorry.
A small mistake in the while issuing notice had been detected, my lord. Actually, it should be the registered post to the respondent number 4, my lord, but it is
Not 6.
not 6.
What is the order of the court?
My lord, the notice was issued and my lord.
No, what is the order of the court? For 6 or 4?
No, my lord, it was for 6, my lord. There was no 6.
It's ought to have been 4.
4, my lord.
It is stated by Mr. A.R. Bhuyan and counsel for a petitioner that when notice was issued by the order dated 16/8/2023, it ought to have been noticed by registered post on respondent number 4 and not 6. Due to the said discrepancy, the service cannot be effected. The order dated 16 be now read to be a requirement of the petitioner to take steps by registered post on respondent number 4. Petitioner may accordingly take the steps.
Interim order may be continued. There is an interim order.
Why?
Lord, it was on the next returnable date that.
No, you obtain interim order with a wrong respondent.
No, my lord, the respondent on our part was correct, my lord.
Interim order to continue.
Highly obliged.
63.
Yesterday, Mr. K. Gugui appeared. Because we don't mind hearing you,
Yes,
but there has to be
For the
continuity.
time being, he is on lakes in court number 4.
Did you find out anything?
My lord, I have filed the affidavit, my lord.
No, affidavit will not be of any help to you. Even your stand will not be of help. We have to go against you on that submission. We are quite clear in our mind. No point in trying to raise arguments here and there. Mr. Das, suppose out of several color blocks, you are required to pick up orange. Orange is not there. There's no point in saying that there is red and yellow. If you mix it, there will be orange. Is it not so?
It is correct, but my lord,
Again, you are arguing. Then we'll hear you. We'll not help you in any manner. We'll hear you on merit. This is the difficulty I told you yesterday we had with you. You are always only argumentative. That's why you explained you the meaning of an argument by a lawyer. We explained you does it mean by argument by a lawyer. It has two clear meanings to be repeated. One, a heated presentation of words. Another, a logical presentation. Argument by a lawyer is the second meaning, never the first meaning. And I told you in the morning itself, we are trying to help you. It appears you are still not ready to accept our help. So you argue in your own manner. I am not going to ask you anything. Start. Case will be decided as per your submission. No, yes. Okay, start your argument, please. In whatever manner you want to argue, you just go on.
I'm confused whether I should argue or not.
I don't know. You decide your own confusion. No one is here to help you with confusions. Up to you.
Logical point, that means, my lord, on the debate.
We are not on any debate with you. You just go on arguing. That's all. Nothing will be asked to you. Nothing will be. Okay. You argue in any way you feel like. Take your call. Start, please. And we have no time for you anymore. Please start. Given enough of time for this matter. Please start. We thought we had a constitutional obligation to give justice to the people. Therefore, we tried to point out something. If the learned counsel engaged by the litigant is not interested, we are also not interested. We are ready to hear way you present, and we are going to decide the way you argue. Yes, please start.
Well, I'm sorry if I'm anyhow I'm disturbing my lord.
You are not disturbing anybody. You are most welcome. Please start. We have other matters to take up also. Please start.
Yesterday, my lord, lordship raised the issue that
I have not raised anything. We withdraw everything we have asked you.
on which point, my lord, I should make my submission.
You start from the
If
beginning.
lordship is not.
No, you
not
start from the
asking me
beginning.
Anything on which point, my lord, I should answer.
Mr. Das, court is not here to answer questions. Court is here only to decide. It is for you to answer and also submit. Start.
Then, my lord, their affidavit, my lord, that affidavit is not complete. What
No,
the
start from the
affidavit-
beginning. I have forgotten everything. We are starting.
Yes, my lord, this is an application, my lord, we have filed for a service benefit, my lord, for this 4 numbers of petitioners, my lord. They were appointed under regulation TF initially, and their service was, it was continued for more than 1 year duration. And as per the UGC regulation, my lord, their past service, ad hoc service to be counted for their service benefit. I'm not claiming the seniority, my lord. It is only the service benefit, my lord. So accordingly, my lord, we have we were appointed in the year 1992, my lord. Our appointment orders were, my lord, Annexure 1A, 1B, 1A, 2A, 3A, 4A, and 5. Actually, one petitioner he has withdrawn from the list of petitioners, my lord. Thereafter, my lord, their services were regularized. My regularization are, my lord, 1B, 2B,
Page number.
my lord.
Regularization page number. Appointment page number, regularization page number.
Appointment, my lord, page 17. Petitioner number 1.
Yes.
Next, my lord, regularization 18. Then for petitioner number 2, my lord, appointment 19. Regularization, my lord, 20. Then petitioner number 3, my lord, appointment 21. Regularization, my lord, 22. Then, my lord, one development petition number 3, he has withdrawn, my lord. Then, my lord, petition number 4, my lord. Petitioner number 4 is appointment, my lord, 23. And regularization, my lord, 24. And the petitioner number 5, my lord. Appointment 25, my lord. Regularization, my lord, 26, my lord. They were appointed and accordingly, my lord, appointed under regulation TF, and thereafter, my lord, they were in service for more than 1 year duration, and accordingly, their services were regularized later on. Thereafter, my lord, one notification was issued. That UGC regulation, my lord. It is at page 27, Annexure 6. It has a part, my lord, page 31.
Page
27, my lord, Annexure 6. It is the UGC regulation, my lord.
6. Okay.
The relevant page is at page 31, my lord. It is a part of Annexure 6, my lord. Page 31, relevant clause is clause 8.0.0, and the most specifically it is relevant at 8.6.0, and that is subclause B. As per subclause B, my lord, it was their issue that ad hoc service of more than 1 year duration can be counted, provided the incumbent was appointed on the recommendation of duly constituted selection committee. So, my lord, thereafter after this, my lord, regulation, my lord, the government issued a notification. That is Annexure 7, my lord, page 32. Annexure 7, page 32. This notification was dated 13 January 2000, my lord. This notification, it excludes the counting of past service period, my lord. This notification was not covering that part, my lord. That is why, my lord, the petitioners were given the service benefit, that is.
No, what is there in page 32? Which provision, which relevant line?
In which annexure, my lord?
Page 32.
Page
which relevant provision was relied upon?
Page 32, not my lord, page 31.
It is, my lord, last part, 8.06.
No, page 32 you referred. After 31 you
Page
referred to
32, it is
32.
Annexure 7, my lord. Here, my lord, it was on a notification dated 13th
I
January
understand
2000.
which particular provision of page
Yes,
32.
this particular provision means this notification, it covers everything, but it doesn't cover, it did not cover that part of the UGC regulation, that counting of past service. It was not covered by that notification.
Then why are you referring to this one?
Yes. Why I am referring this one, my lord? Under this, my lord, while we claim the benefit.
You claim benefit under this one?
No, my lord, under regulation TF. Under regulation
Mr. Das, you never answered that. In your course of your argument, why did you refer to Annexure 7?
Yes, my lord. Why actually it was
relied by them, it was relied by you.
Yes, my lord, this is relevant. Why it is relevant, my lord? After, my lord, this UGC regulation, they prepared a list, my lord, for this service benefit. They excluded our names, and it was issued in the year 2010, my lord. That list, my lord. In 2010, my lord, they issued that list that who are going to get that benefit, and that notification was again recalled in the year 2010 itself. Then, my lord, some other similarly situated persons, they approached before the Assam Administrative Tribunal, Learned Tribunal. Then the Learned Tribunal decided the issue. It is, my lord, Annexure 13, page 54. Annexure 13, page 54. Here, my lord, very relevant part is at page 57, my lord. Page 57, para 4, my lord. Para 4, may I read, my lord? Para 4. May I read, my lord? It is.
You don't have to ask what you want to read. You go on reading as per your own wish.
It is claimed by the appellants that since they have attained the required qualification and criteria for their placement in the senior scale and selection grade scale, the state selection board had recommended their placement in the senior scale, and accordingly the government notification dated so and so published in the result of the placement where their placement in senior scale was shown as so and so respectively. However, the appellant were not satisfied with the said placement since according to their past ad hoc service under regulation PF of the APSC regulation of more than 1 year duration were not counted in the placement which they are entitled as per UGC notification. Being aggrieved, they gave a representation to the Commissioner and Secretary Higher Education Department for a review of effective date of conferment in the senior scale. Government placed the matter before the selection board. The selection board reviewed the matter and taking into consideration of the UGC norms recommended press selection list of candidates for placement in the senior scale of pay. Accordingly, the recommendation of their effective dates of placement in senior scale and selection grade were notified by notification dated so and so 2010. Accordingly, to the appellant's effective date of placement in the senior scale and selection grade reflected in the state notification has taken into account their past ad hoc service under regulation TF of the APSC regulation as per UGC notification. It is, however, alleged by the appellants that the subsequently government responded in Education Higher Department without referring matter to the state selection board in an arbitrary manner by notification dated 24/9/2010. Cancel the earlier notification dated 10 July 2010 and by impugn notification modify the effective date of placement of the appellants in the senior scale and selection grade respectively without taking into their past ad hoc service under regulation TF of the APSC regulation which they are entitled to be counted as per UGC notification. Hence, they urge that the same notification dated 24/9/2010 which was issued arbitrarily without following the guidelines of UGC notification to be set aside and was as the impugn notification has the effect of depriving the appellants their financial upgradation to the higher pay scale, senior scale and selection grade respectively, and a direction may be issued conferring them the effective dates of their placement in the senior scale and selection grade taking into account their past ad hoc service in the regulation came of the APSC regulation. Government respondent has filed the affidavit in opposition questioning contesting the claim of the appellant. It is stated in the affidavit that in pursuance of UGC notification on revision of pay scale, minimum qualification for appointment of teachers in university colleges and other measures other measures for the maintenance of standards 1998, the government issued an office memorandum dated 13 January 2000, accepted various measures in this regulation, which provides for career advancement initiative for placement of the lecturers in of the university and colleges in the senior scale and selection grade respective. But it is mentioned that counting of past ad hoc services while conferring the benefit to senior scale and selection grade was not provided in the said government office memorandum dated 13/1/2000. Since the government has not adopted the provision for counting of past ad hoc service while conferring placement of the lecturers in the senior scale and selection grade, the past ad hoc service will not be counted. And hence, when it comes to the notice of the government that by notification dated so and so, placement of the applicants had been wrongly recorded in the selection senior scale and selection grade, counting of their past ad hoc service, government has re-examined the notification and after obtaining a report from the Director Higher Education issued a notification dated so and so, cancel the earlier notification. Then, my lord, hereby, my lord, it is clear that the government notification it did not cover the counting of past service period, and accordingly, my lord, the another relevant page is, my lord, may come to page 62. Is 62, my lord, para 10. It appears from clause 8 that counting of past ad hoc service of more than 1 year duration has been recommended by said notification in placement of lecturers in the senior scale and selection grade. However, the government respondent has stated that they have not accepted the counting of past ad hoc service. Now the question arises whether the government has the authority to exclude any condition from the UGC notification as a prerequisite to eligibility for conferment of senior scale to the lecturers. It has been held by the Honorable Supreme Court in civil AP number so and so that it was not right on the part of the state government to depart from the rudiments of the scheme recommended by the UGC for conferment of a higher pay scale to lecturers and to devise a new mechanism entailing the imposition of fresh condition as a prerequisite to eligibility for the higher pay scale. As held by the Honorable Apex Court in the aforesaid case, we also hold the view that the government authority, while issuing the office memorandum accepting the recommendation in the UGC notification, cannot be devise a new mechanism and exclude a condition counting of past services for of more than 1 year duration recommended in the UGC notification for conferment of placement in senior scale and selection. For the reasons aforesaid, we are of the considered view that government respondent in the higher education department has illegally issued the notification dated 24/9/2010, cancelling the earlier notification dated 10/7/2010, where the effective dates of placement of the appellants in the senior scale and selection grade have been correctly recorded, and modify the effective date of placement of the appellants in the senior scale and selection grade without obtaining the recommendation of the selection board and without taking into account the past ad hoc service of the appellants under regulation 3 of the PSC regulation, and thus clearly violated the UGC notification. It cannot sustain. We therefore set aside and quash the impugn notification dated 24/9/2010 and directed to restore the notification dated 10/7/2010. Thereafter, my lord, they approached before the Honorable High Court against that judgment, my lord, the state authority, my lord. That is a page, my lord, 64 Annex 14, my lord. This writ petition is directed against the judgment and order dated 14/8/2012 passed by the Assam Administrative Tribunal, Guwahati, in case number so and so, by which it has been held that once the UGC guidelines are accepted, it will to be accepted on not on piecemeal basis. The stand of the state government in reference to the UGC guidelines is that since in the notification that was issued pursuant to the UGC guidelines, there is no mention of counting of past service rendered on ad hoc basis, that part of the UGC guidelines may not be applicable to the case of the respondent who was the appellant before the tribunal. I have heard Mr. P.N. Goswami, Learned Standing Counsel, Education Department, appearing for the state government petitioner. I have also heard Mr. So-and-so representing the respondent who was the appellant before the tribunal. Learned counsel for the petitioner clearly submits that the stand of the state government may not be tenable in view of Apex Court decision dated 17/7/2013 passed in civil AP number so-and-so. In the said judgment, it has been held that UGC regulation cannot be applied in part, but will have to be applied fully, merely because the state government has issued a notification in reference to the UGC guidelines without mentioning a particular part of the same. It cannot be argued that the said guidelines or the part thereof.
Mr. Das, why are you hearing you? If you only have to read what you are reading, You can point out page number so and so, paragraph so and so, read, this is my case. We'll pass our order. We are hearing from you to orally know what you are trying to actually say. We can also, it is already before us, we can also read. It's not that a court doesn't know to read, somebody has to read it for the court.
My lord, my understanding.
So why are you, when you read it?
It will be helpful for the court to decide the issue, my lord.
What you are trying to say by reading all this?
Yes.
That is a difference between submission and reading.
That the state government, they cannot
If I understood rightly, the only purpose of this last 15 minutes of reading is that the UGC notification cannot be taken in part.
Yes.
Meaning thereby that clause 8 or 6 or whatever it is of that relevant page, I think it is page 31,
yes,
has to be taken note of. We'll take note of it. Yes, now go to the next point.
Thereafter, my lord, impugn judgment. In the impugn judgment, my lord, page 71, yesterday also I read out. Here also the same issue, my lord. The learned tribunal, where we approached before the tribunal just held it. Tribunal just held
page number?
Page 71, my lord. Third para.
Yes, go on reading. Go on reading. Do it. Please continue. Don't stop.
Yes. We have very
because
strong,
we have some other people also waiting for their turn.
para 3, my lord. We have very strong reservation for the judgment dated 14/8/2012 because referring that particular judgment, my lord, because of which we are not inclined to entertain this application. In the said judgment, this tribunal has held the date of appointment should be deemed to be the date of appointment under regulation 3F and that the benefit of the service should be counted for the purpose of seniority to make the persons eligible for upgradation to senior scale and selection grade by taking into account the service rendered by the person as an ad hoc appointee appointed under said regulation. In arriving at this conclusion, the tribunal has quoted a ruling of the apex court. In this, the Honorable Supreme Court has held that the government is not right in making a departure from the rudiments of the scheme recommended by the UGC for conferment of higher scale of pay to lecturers and to devise a new mechanism. They have quoted clause 8 of the UGC notification laying down the guidelines pertaining to counting of past ad hoc service for the conferment of senior scale and selection grade to lecturers. In the tribunal, the tribunal has concluded that the lecturers fulfill the conditions laid down by this clause and government was not right in making a departure. This interpretation is not correct as this part is very relevant, madam. Page 72. The tribunal held that the Supreme Court, what the Supreme Court has said, that part is not correct. This interpretation, the interpretation which was given by the Honorable Supreme Court, that interpretation is not correct. Why? Because the subclause F of the clause 8.6.0 as quoted in the said order of the tribunal stipulates the condition, that is, my lord, the incumbent was appointed on the recommendation of duly constituted selection committee. Here, my lord, they are directly referring that the duly constituted selection committee means the APSC. But this part is not correct, my lord. And the affidavit, what they have filed, my lord, in their affidavit, they are referring another notification. That is of, my lord, notification of same 2000, my lord. It was of 26/5/2000, my lord. That notification, it is nowhere we have found, my lord. Neither we have annexed, nor, my lord, they have produced before the honorable court. Thus, they have referred that in their affidavit, my lord, running page, my lord, page 83. There, my lord, in the paragraph 6, my lord, they have stated that the deponent begs to state that as per government notification dated 26/5/2000, the persons who are working as lecturers under Regulation 3F of the Assam Public Service Commission, Regulation 1951, shall be deemed to have been regularly appointed to the post from the dates they were recommended by the Assam Public Service Commission. The date of recommendation by the Public Service Commission of the petitioners are as follows. This notification, my lord, we have not found it. Even they have also not produced before the honorable court. On what basis, my lord, they are saying this? It is not clear, my lord. And other part, it is which one is very relevant, my lord. They have just said that we were appointed only for a period of 4 months, my lord. That is not correct. If that was their contention that we were appointed only for a period of 4 months, then we have also no claim, my lord. If that is the case, but our case is different. We were appointed. For some petition it was for 2 years. For some petition like 1.5 years, my lord. It is not that we were appointed only for a period of 4 months, my lord. So they are relying their entire, my lord, this issue that we were appointed only for a period of 4 months. That is why, my lord, we are not entitled to it. And they are referring another notification which is also not there, and they are even not referring that notification which they issued, my lord. And our petition, it was not replied by them by Parawise, my lord. So, my lord, this is, my lord, very much clear, my lord, that they are just trying to refuse us. But as per law, my lord, as per the regulation, my lord, we are entitled to it. And we have replied with our, my lord, affidavit in reply, my lord, their issue. And thereafter, my lord, Lord Lordship has directed me to file the affidavit today, my lord. We have filed that they are not relying upon any record, my lord. They have just made the statement before the honorable court that we were not appointed by the duly constituted selection committee. On what basis, my lord, it is not clear. Kindly, that record may be produced before the honorable court, my lord, to determine the issue, my lord. Otherwise, my lord, we are entitled to it.
Yes, Mr. Gogoi.
Lordship.
Your stand is your records does not have it. Now you produced a record which does not have it.
Lordship.
If the record has it, we can direct you to produce this one.
Lordship.
If the petitioner requires to produce a record which you don't have,
how can
you produce it? I don't know.
Lordship,
This is the submission.
Admittedly, their appointment is TF, Lordship.
Understand?
Lordship.
Ultimately, what we found that whether selected by the duly constituted committee, you say that you don't have any record of any duly committee selecting them.
Lordship.
He wants you to produce the record.
Yes, because he is the TF appointee, Lordship.
I don't know.
TF appointee.
And the only way you can do is, that means every record you have in your office has to be produced.
Lordship.
Then somebody will verify whether this is there or not. It is not possible. So we allow Mr. P.K. Das to visit your office.
Lordship.
You make available every record available
Lordship.
in your office. Ask him to find out and point it out.
Him.
Once he points out, you produce it before us.
It is the duty to him to, Lordship, produce the whether he is the.
Otherwise, how do we meet this request from the petitioner?
Lordship. It's a TF appointee admitted position, Lordship.
After hearing Mr. P.K. Das for a considerable length of time, and upon having taken the court through the relevant materials at pages 31, 32, 57, and 64 of the writ petition, and also on the question set when the matter was heard yesterday, that the respondents are required to produce the records of the selection of the petitioner, which according to the petitioner was done by a duly constituted selection committee. And in the background of the submission of Mr. K. Gogoi, that there is no such record available in the department of the petitioners having been selected by a duly constituted committee. And taking note of the serious request by Mr. P.K. Das, learned counsel for petitioner, that the records of not being selected by duly constituted has to be produced. We are at a loss as to what order is to be passed and which record is to be directed to be produced. In the circumstance, we direct the respondents to allow the land counsel for the petitioner, Mr. P.K. Das, to visit the office of the respondents and allow him to examine any record he desires to examine. And after such examination, if any of the records is pointed out as to which would be relevant, the same may be informed to the court, and the court will direct the production of such records. This next week. And the date and time of the visit of the land counsel may be intimated to Mr. K. Gogoi so that his examination of the records can be facilitated.
Item 55, my lord, I apologize, my lord, I was in Lakes Court 54.
What happened?
17. What she was directed the personal appearance of the mission director. I was supposed to place certain instructions, my lord.
No, that is on a totally different cause.
No, on that point only, my lord. That, my lord, regarding that visiting of the police to the residence of the petitioner on that point. But in fact, my lord, today, if already order has been passed, can I make one or two?
No, we have not signed the order because it's.
In that case, my lord, item 55, my lord, one or 2 points.
No, mission director, we only vicariously require because Mr. Saikia says that the ADC and all are doing all these acts on the instruction of the mission director.
The ADC, otherwise, district mission coordinator is the additional deputy commissioner of this particular district. But here, what has happened, my lord, that Lordship may kindly, if the file is available, my lord, the record.
File to lay us.
One communication, which is a part of the earlier order passed by this honorable court, it has been quoted there. Just Lordship may kindly see, my lord, that communication. It's of 21st of September 2021. Well, this was part of the writ petition, or it was placed before the honorable court when the earlier writ petition was disposed of. In fact, my lord, this particular report is in favor of the petitioner. Accordingly, on that, my lord, all the parties considered that, my lord, if since, my lord, the report is there, which is in favor of the petitioner.
No, we are perturbed with something different.
It relates to that.
We are not perturbed with on the facts of the case. We are perturbed. One what? Wazazul what?
Wazadul Hassan.
One Azazul Hassan rings up the petitioner. Read that. I don't think we have gone through that. Para 3 and 4. We are not concerned with the merits of the case.
Well,
DMC has not. Mission director district.
Well, regarding that part, my lord, I have
read it completely.
May I read it?
I don't think you will also appreciate it.
That this honorable court, while adjudicating the cause, asked for certain instruction from the respondent by order dated 28/8/23, 11/9/23, 21/3/23, that while the writ petition is pending before the court, one Mr. Wazadul Hassan, programmer, MIS of the Office of the Block Mission Coordinator, Borpeta, informed the petitioner from his mobile phone to appear before the office of the ADC, Borpeta, Lakshmi Datta, with all records on or before 21/9/2023. The petitioner, while wanted to know the reason from the said BMC, that is Wazedul Hassan, he pretend the petitioner that if he does not appear, then police action would be taken against him. That the petitioner, being a law-abiding citizen, is very much obliged to appear before the appointed officials, and therefore it did request the said Wazedul Hassan to issue a notice to his appearance in the appointed
Mr.
office.
Bhuya, also take note of if this allegation is, we'll make an inquiry. If it happens to be incorrect, the petitioner will be again in problem. Also take note of that. Please read.
But the said request of the petitioner had been turned down, and therefore the SDC cum circle officer of Mandia Revenue Circle, Mr. Tunbor Chutia, along with the village headman of Chatra Kanara village and the police of Mandia police station, came to the residence of the petitioner at around 3 p.m., 4 p.m. and 5 p.m. and at around 7 p.m. at the residence of the father-in-law of the petitioner around 29/2023 at the aforesaid village with an intention to pick him up for his appearance. As the petitioner was not present at that time, therefore the aforesaid team of officials further informed the neighbors as regards to inform them as and when the petitioner remained present in his aforesaid residence. that today at around 11 a.m., the aforesaid SDC circle officer called the father-in-law of the petitioner from his personal mobile phone bearing number so and so. He called the father-in-law of the petitioner, Akbar Ali, aged 67 years, over his mobile phone bearing number so and so. And while threatening him of police action, further warned him to make the petitioner available before the office of the ADC cum district mission coordinator Borpeta on or before 12 noon today. And when the father-in-law of the petitioner wanted to know the reason, he simply replied that some signature of the petitioner deponent is required. But the petitioner is now being frequently threatened over his mobile phone by the said Wazidul Hassan and informing.
Okay, I think.
My lord, here, one thing, my lord, these are some allegations level. At least 1 week's time may be given to us so that we can revert to this thereafter.
No. On the allegation, we are taking on Monday. These are extra constitutional matters.
That's why, my lord, this
just a minute.
Cross the limit, I suppose.
The reason may be good. Reason may be for the best of the purpose. But the method under the constitution is unacceptable.
But my lord, I have
Whatever
specific instruction from the mission director today morning.
No,
also.
mission director.
He has not instructed.
No, mission director. We have required Mr. Saikia has made a statement. The additional deputy commissioner says that I have done all this on the instruction of the mission director.
But that I have specific instruction, my lord. Today morning also I have called up the legal officer. He has informed that from their part.
We wanted the mission director for one statement that I have not instructed. Once mission, because mission director, we have nothing against him. Mission director has not threatened. Mission director not the thing. Only one line of Mr. Saikia that these officers are acting on the requirement or direction of the mission director. That's the reason mission director. You explain him.
Otherwise, my lord, instruction is specific, my lord, that he has not instructed. That I already have. Lordship may record that tomorrow if the officer appears before this honorable court, the circle officer or the ADC,
mission director to
only on that part, otherwise, my lord, he will appear, my lord. If it is found that, my lord, it is as per his instruction and I am wrongly instructed, Lordship may definitely
mission director personal mission director katiba. Baki kita thakok. Can this is heavy rated?
No, I understand, man. Going by the affidavit, my lord, they have crossed their limits.
I think we are living in a civilized country.
I understand.
And where a constitution still prevails.
One more thing, if Wazidul Hassan being the official of under the my lord additional deputy commissioner under the mission that
so we want
him also appear.
No, we want him also.
Yes, it will be more convenient. He will.
Did we pass the order on Wazidul? Okay, Wazidul to include Kori Dibo. But he is the main one. He has to be included because he also may be wrongly doing everything. You don't know. ADC may come and say that I never asked Wazidul to do all this. He may be doing on his own volition. No one knows.
Lord,
petitioner is present today. Let him be present on Monday also.
Petitioner also. Let the petitioner also remain.
Yes, my lord.
So that they can
my lord.
face each other.
My lord, he in fact is present today also in the court, my lord. If my lord allows, my lord, then
let them all the parties be there.
See, whatever it is. We've been told that the ADC and all needs some document from him. I think that CPC provision is, Mr. Bora says it is order 49 or something. It may not be 49, it is another.
Order 11 rule 14.
That's a one.
Order 11.
There is a procedure how documents in the court of law can be obtained, which is in possession of the other side. We don't follow CPC also.
Yes, sir.
Make a request, we direct them to produce it. But
fact,
why do we have
block
to?
elementary education officer can do that. My entire reports are submitted by him, so he can come up with that if required.
So why do we have to threaten them, man? This is
they are running after the wrong person.
no, this threatening. No,
stage,
whatever it is, maybe right person also. Maybe he is a very unscrupulous, holding a document, not giving. Still, method used is we are. I don't think you will agree with that method.
That part, while reading, my lord, I agree to that. But, my lord, we have found, my lord, there is some manipulation in the record. Issue register, that dispatch register of that particular letter. On that ground, my lord, the MD, my lord, asked the, my lord, deputy commissioner, additional deputy commissioner.
Manipulation by whom? By the petitioner.
That they are supposed to inquire, my lord.
Inquiry.
Yes. That liberty of lordship give, my lord.
No, not today.
On Monday, lordship.
First, let us sort it out why extra constitutional methods can never at least when it is brought to the notice of the court, no extra constitutional methods can be allowed, whatever it is.
And if these allegations are false, my lord, the
The
petitioner will
rule of
suffer.
law has to prevail.
Yes, rule of law will have to be prevail. That's the main thing.
That diplomatic role, you must be following it closely. There also the same thing is a rule of law has to.
Yes.
On Monday, the petitioner will also be present, my lord.
I'm deeply obliged.
Obliged.
Don't threaten anybody. Don't do all these things.
Lord.
If you need something from him, ask him. Give him a notice that it is understood this document is in your position. Kindly place it before us for our examination. End of the matter. He's bound to
My
go.
lord, before receiving that document, my lord, we have received. He has already annexed in the writ petition. He got the order. After 1 year, we have got the letter. September 2021, we have received in
See,
September 2022.
Again, if he has committed fraud,
Yes, yes.
you
On
tell
Monday,
us.
we will definitely pray.
You tell us. But
Not he, my lord, our officials are also involved.
But
because without them, he cannot have a
understand.
letter.
But that doesn't mean even against a fraud, you are going to take extra constitutional measures.
That's part.
That has to be also as per law.
Oh, like
বাকি সেই mission director তো কাটি এইখিনি কৰি থৈ দিলে। আৰু সেই ৱাজেদ হেৰি নেকি ৱাহিদুল পাৰ্টিকুলাৰ নামটো চাই ল'ব
Wazedul.
নহ'লে আৰু ভুল মানুহ এটা আহিব
Wazedul Hassan, the affidavit.
WAJDUL. Wazedul. Wazedul Hassan. HASAN Hassan. Programmer. MIS of Office of the Block Mission Coordinator Borbeta.
otherwise again another wrong person will come to the court.
Paragraph 3 of the edition letter. Page 85. Block of the
Yes, Mr. VP Bora, what is your matter?
No, Lord, I came.
Oh, withdraw.
Withdrawal.
Withdraw, you have to, it has to be by
I know,
somebody whose name is on record.
Someone stepping down. Lord.
And that is okay, but otherwise we cannot withdraw on somebody else. Mr. VP Bora, the counsel of petitioner states that there is instruction for it not to proceed this petition any further. In view of such statement, writ petition stands closed on being not pressed. Any liberty? Not required.
No, we have
Already
already
appointed.
already.
Thank you.
May please, Lord. Seems a contempt.
Contempt.
Has not been complied.
I don't know, prayer, Mr. Gogoi,
I have,
for obtaining certain clarification as sought
Lordship,
for.
I have received instruction, Lordship. Yesterday, Lordship, Health Department has given the admissibility certificate, Lordship. On the basis of the admissibility certificate, Lordship, we have sanctioned the amount today, Lordship.
This is regarding what?
Regarding, Lordship, medical reimbursement, Lordship.
Medical reimbursement.
PT.
Okay. Mr. K. Gogoi, learned counsel for the, for whom are we appearing?
Lordship, I am for the respondent number 2.
Word of which department?
I am for 2, Lordship. Higher.
On behalf of the respondents in the
2, 4, and 5, Lordship.
in the higher education department, has produced a communication from the Director of Health Services Assam to the Joint Secretary to the Government of Assam in the Higher Education Department dated 21/9/2023, by which what to write?
Lordship. Lordship.
We have stopped in the middle. By which? What to write?
That amount, Lordship may record it, my lord. Admissible amount.
What is the admissible? What? 178, that one?
178, Lordship.
That
178,
that there is an admissible amount of rupees 1,78,870 towards the medical reimbursement bill of the petitioner. Now, what will be the second stage after this?
Then, Lordship, next page, Lordship. Next, another document is there, Lordship. Lordship.
Accordingly, the Joint Secretary to the Government of Assam in the Higher Education Department had sent a communication dated 22/9/2023 to the Principal Accountant General A&E Assam for payment of rupees 1,78,870 towards medical reimbursement bill to in respect of late Dhiraj Kumar Sharma, former assistant professor of Bozali College, Pathala, to be with a copy to Srimati Urmila Devi, who in fact is the contempt petitioner. Accordingly, it is directed and expected that the amount of rupees 178,870 would be paid to the petitioner Urmila Devi. After this, what is the stage? Payment or something more?
It will be payment.
Payment within a period of 15 days from
Lordship.
today.
The amount is Lordship 5,97,000. Lordship.
That you have to file writ petition. We cannot decide in a contempt.
Two claims, my lord. One is, my lord, in a referral medical hospital, which is there in the chart of the, my lord, medical attendance.
Understand that?
That part we have admitted.
No. That you will have to file a new writ petition. Contempt doesn't mean that whatever claim if not paid is a willful and deliberate violation. Contempt is whatever under the law they feel, if paid, that is sufficient compliance. And if you still agree, you can accept this amount, file one more petition, we'll ask them if the calculation is wrong or the sanction is wrong.
That part maybe.
Accordingly, the Principal Accountant General A&E Assam is directed to do the needful for that the petitioner Urmila Devi receives the said amount within a period of 15 days from the date of receipt of the certificate copy. A copy of this order be also submitted by the contempt petitioner in the office of the Principal Accountant A&E Assam, because he is not a party here.
Lordship kept open to the petitioner to challenge that observation may be there. Because Lordship.
However, Mr. S. and Christian Taya, the counsel for the contempt petitioner, expresses dissatisfaction over the amount of rupees 1,78,870, stating that it is inadequate and not the appropriate amount the petitioner is entitled. If it is so, petitioner given the liberty to assail the said order. But however, the admitted amount be paid to the petitioner in the meantime. Otherwise, you will not get that also.
Yes, sir.
Take whatever getting, unless you challenge it with hearing.
This is one where my desire has settled, Lordship, where as per order of this honorable court, this order is directed to pay Lordship amount of 5 lakh out of 6 lakh something, 6,87,000.
Court has quantified it.
Yes, Lordship. Order pays 15 is the operative part, Lordship. Order pays starts at page 12. Page 12, Lordship. Order starts at page 12. Order starts at page 12, Lordship. 15 is the operative part. Page 15, paragraph 10, Lordship.
You have already sanctioned 959. Why did you reduce it now?
It is a proposal for sanction.
It was a proposal for sanction, my lord, 597,730. Here, my lord, as per our note sheet, my lord, my instruction is that petitioner, my lord, for a particular part of this amount, my lord, he got treated in a referral.
We have taken note of the provision at para 10 of the order dated 17/11/2021 that as per the communication of the Director of Higher Education Assam dated 15/9/2016, there is a sanction of an amount of rupees 5,97 towards 737 towards a medical reimbursement of the medical bill of the petitioner in respect of a deceased husband. But it is, and accordingly, the departmental authorities in the Higher Education Department, Finance Department, and Health Department were directed to do the needful to ensure that the sanction amount of rupees 597,737 be paid to the petitioner. But in course of the hearing of the contempt petition, it is clarified both by Mr. K. Gogoi, Higher Education Department, as well as Mr. B. Gogoi for the
Finance and health.
Health as well as the finance department that the said amount was merely a proposal for sanction and not a sanction by itself. The said, if the petitioner is further aggrieved, the said aspect may also be assailed. In contempt, we cannot do anything.
Yes, yes. My research is
Contempt, we can only.
Yes, Lordship. Actually, they ought to have filed a review or appeal.
Contempt, we can
against this
only
order.
twist their arm to some extent so that
Yes,
it
Lord.
comes out.
Yes,
We
Lord.
cannot do anything beyond that.
Exactly, exactly. Deeply understood.
Item 58.
I received two page of notes. Notes actually some other documents they could not send because there is nobody.
Let it listed on Monday.
Lordship, this.
Can we?
Lordship,
Is Mr. Bhuya satisfied with these two documents?
I have not shown here.
I have not done for my Lord. Lord, can it be fixed on Monday, my Lord? We will take.
Then Lordship, it may be.
The following detailed list of two selected candidates for admission in the lateral eligibility available so and so. So this is the merit list.
My Lord.
So your prayer number 1 is taken care of. Prayer number 2 is to extend the date of admission. If you are not selected, it is not relevant. Provide the petition opportunity to take admission. If you are not selected, not relevant. Direct command to dispose of the representation. It's not required anymore.
My Lord, what has happened?
We'll take note of these two, close the writ petition, give you liberty to assail it if you find it is illegal.
My Lord,
In this writ petition, Mr. Bhuya, you know what can we do? We cannot do
I
anything.
cannot challenge it, my Lord.
So,
my Lord.
instead of delaying the matter for you,
My
we
Lord.
give you time to challenge it if it
Yes,
is
yes,
wrong.
my Lord. That would be. But my Lord, if it is in.
It is for your benefit.
Yes, yes, I can.
And if we keep this one, present one pending,
My Lord.
same order, you'll get it after 1 week.
It will not serve.
You want it today or after 1 week?
Yes, Lordship.
But the order will ultimately be same.
Yes, my Lord can close, my Lord. My
Considering the nature
Yes,
of the
yes,
prayer.
yes, my Lord.
Heard Mr. E.R. Bhuya, Learned Counsel Petitioner, also heard Mr. S.T.K. Learned Counsel for respondent in the Assam University. The writ petitioner had participated in this, had offered this candidature for admission to the B.Tech bracket lateral in agricultural engineering for the session 2023-24 under the respondent Assam University. In a circumstance, this petition is instituted with the following prayer. ABCD code for DD1. Mr. S.C.K. Learned Counsel Assam University has provided the court with a copy of the merit list for the subject B.Tech lateral entry agriculture and engineering, which does not contain the name of the petitioner to be selected on merit. But however, the production of the merit list does satisfy the requirement of the prayer number 1 for a direction of production of the said list. The prayer number, as the name of the petitioner does not appear in the merit list, the prayer number B, C, and D would be irrelevant for the purpose. Full stop. Accordingly, we do not feel any necessity of either issuing notice or keeping the writ petition pending any further. A copy of the result sheet provided by Mr. S.C.K. is kept on record, and a copy thereof is also provided to the Learned Counsel for the petitioner. If the petitioner is aggrieved in any manner by the merit list, liberty remains to approach again. It will be faster for you. We can come back on Monday. But if I keep it pending, you'll be stuck for some
I can
time.
understand. It will help our cause. Highly obliged, my Lord.
এখন সেই কালিৰ হেতুকে চব থৈ দিব হে আমাৰ যে বি গগৈ দিলে যে সেই যে পাৰ্চনেল এপিয়াৰেঞ্চ এটা তুমি নাছিলা নেকি তেতিয়া কোন নাই আছো
কোনটো এয়াৰ ভূঞা 55 হৈ গৈছে না
আছে নেকি কিবা আৰু
এই দুটাই
আৰুতো নাই
মেডিকেলৰ এই দুটা
Mr. Goi, medical, you are here. Should I continue? Or
Anise, order to Anise.
Monday also, my lord.
or Monday?
Order to Anise.
Not inconvenient.
So Mr. Kamali was here, but because of the medical emergency, he had to
Yeah,
leave
to
the-
go. Monday you will come.
Monday.
But only thing we wanted, anyway, it won't make much difference between today and Monday. We just wanted to give a window to SLD order if you are still aggrieved before 30. That's why we are trying to hurry up. Monday.